Welcome, Kim. So we have the medical board report.
Thank you very much. And again, I just want to really thank the board members and Ms. Harold for having me here today, really to talk about the activities of the medical board and a lot of joint collaboration between the two boards. At our last meeting, a member requested that our board staff actually begin a collaboration with the Board of Registered Nursing and the Board of Pharmacy. Over the past several years, the medical and pharmacy boards have worked very closely on several issues, mostly around the issue of opioid misuse and abuse. However, this new collaboration would bring more boards to the table. This collaboration stems from what is occurring at the national level right now. At the national level, the Federation of State Medical Boards, the National Council of State Boards of Nursing, and the National Association of Boards of Pharmacy hosted a tri-regulator meeting. At this meeting, they looked at successful team building, new practice models, and communication ethics. The meeting was entitled Team-Based Care Collaborative Regulation. And if anyone's interested, I do have a summary of the highlights of that meeting that we recently received from the State Board of Medical Board, so I can pass that on to Ms. Harold and she can forward it to the members. While these meetings will continue nationally, our board would like to actually start our own collaboration here in California. After thinking about starting the collaboration, I thought that it might be good that we not only include the boards of pharmacy and registered nursing with the medical board, but also the osteopathic physicians and the physician assistant board. In several states, these licensees are all under one board, but that's actually not so here in California. This is a great opportunity to bring these boards together to work on issues that impact each one of us. I've reached out to the executive officers of each of these boards, and they've all agreed to meet. We are in the process of setting up a meeting in August. One issue where I think the pharmacy board will be a huge asset in this collaboration is working with the CARES system. The wealth of knowledge within the pharmacy board staff would be very useful to other boards and would really assist in the fight against opioid misuse and abuse. Some other topics to discuss may include collaborative care, continued discussion on ways to eliminate the opioid epidemic. I think outcomes of our group could be education and a united front on some of the issues, again, such as opioid misuse. This partnership is very important in this era as both medicine and technology are evolving. Working together should lead to enhanced consumer protection, and we really look forward to working with Ms. Harold on the formation of this group. The medical board is also pleased to be working with the Board of Pharmacy, the Osteopathic Medical Board, and the University of California at Davis on a CARES survey. That survey will be sent to all physicians whose licenses expire in November. The information on the survey will go out with the November renewals that will be sent next month. The survey asks physicians how CARES 2.0 is working for them and any problems they are having, as well as any suggestions for improvement. This survey is part of a study on opioids and part of a grant work being done by the California Department of Public Health and the Department of Justice. And I want to publicly thank the Board of Pharmacy for its inventiveness on the CARES countdown on its website leading up to July 1st.
That was Amy.
We liked it. We liked it so much we copied it. We put it on the medical board site. So we also did extensive research regarding the CARES registration via emails, newsletters, tweets, and subscriber notices. The good news is that as of Monday, the board actually has 71,491 physicians registered in CARES 2.0. There are also some physicians that are registered in 1.0, but they haven't updated their information in CARES 2.0, so they cannot be identified by the Department of Justice yet as in the physician group. So we're working on trying to identify those individuals and get them also into CARES 2.0. Unfortunately, our board does not maintain a list of physicians who hold a DEA. Therefore, we can't currently identify those who must register. However, we are working with the Department of Justice to identify physicians who have a DEA in order to conduct outreach specifically to them to bring them into compliance with the law. And prior to that July 1st date we worked with the Department of Justice to provide us a list of individuals who are registered so we can compare that with our licensee base. But because the individual actually has to hold a DEA as well as a license, it's hard for us to identify those individuals. So that's what we're going to be working on now. The medical board is also conducting a large outreach campaign entitled Check Up on Your Doctor's License, and this is actually our new brochure that we've put out. We have actually also finalized a tutorial titled Check Up on Your Doctor's License that is posted on our website as well as YouTube. Again, what we found over the time is not that the medical board, a lot of individuals don't know that there is a medical board. They don't know that we're out there. They don't know to check up on their doctor's license, and they don't know where to file a complaint. So that's what our whole goal to this outreach campaign is. Our tutorial walks a patient through the steps needed to check on a physician's license. The board was also able to put a message encouraging state employees, vendors, and contractors to check up on their doctor's license at the bottom of all state warrants for June of 2016. The board has also been able to reach out to numerous counties and cities who have posted information on their websites, and several publications have included our information. With all of the websites, the publications, our board's messaging right now has a capacity to reach approximately 17 million Californians. So we're really excited about this campaign. We're really working towards doing also a PSA on our outreach campaign that then we can take and market it to different news media types. The board also held its second annual legislative day on May 11th. Our day was well attended by the board, and 5 groups of board members visited members throughout the Capitol explaining the board's roles and functions. Again, we can only do it in members of 2, so we had to split everybody up. In addition, board members asked the legislative members to post information on the board's outreach campaign. Several members actually took pictures with our board members with holding our little brochure and then tweeted it or posted it on their website. So we were excited about the feedback from the members, and it was actually a very successful day. Again, I want to thank the Pharmacy Board for inviting me to provide this update, and I really look forward to our continued collaboration on future issues. And I also have Ms. Harold's report in my board packet that will be going to our members, and our board meetings actually starts this afternoon and Thursday and Friday. So with that, are there any questions?
I have a question. We're dealing so much with prescription drug abuse and drug diversion from the pharmacy side. I know the CDC has issued new guidelines for prescribing. Is the medical board looking at this? What's the timeline on issuing updated prescribing guidelines? Because I think the pharmacists are kind of on the end of it, looking at these prescriptions, but they're actually, it's a big provider issue.
So actually what we did is we started in 2012 actually, in the beginning of 2013, and we actually put out new guidelines in 2014, at the end of 2014, November of 2014, that really looked at all of the issues. We've looked at the CDC guidelines. We're going to post them on our website because with them not being a regulatory agency, they were actually able to put a little bit more guidance in there. So they don't contradict each other in any way. They kind of actually work together. And so we've actually looked at those guidelines with the California Department of Public Health in doing a cross match. So we don't plan on revising ours because we just did it in 2014.
There's not a substantive change with the CDC from your guidelines?
No.
Are there any outreach going on to the providers on this? I mean, such a critical patient safety issue.
We've done a lot, even in collaboration with Ms. Harold, going out to different groups, medical groups. We do outreach to them. We've actually emailed our guidelines out to everybody when they were released. In conjunction with the California Department of Public Health, that really jump-started a lot of it with their big work group that they did, because they did a lot of outreach in getting our guidelines out into the hands of physicians.
Yes. So I'm sorry I was late. So on Cures 2.0, is it functional now? That was sort of an issue a few months ago. I don't know what you're hearing these days.
Yeah, actually it is. I mean, we had a lot of calls about getting in and registering. And I think the pharmacy board had the same. It really was difficult for individuals because their phones at the Department of Justice weren't being answered. And so the rollover was to call the medical board and to call the pharmacy board, I'm sure, as well. And so we had a lot of calls with individuals having struggles getting into the registration. One thing we actually found in part of the problems were that either for one reason or another, whether the information they had changed their social security number, like switched a couple numbers when they wrote it out and gave it to us, or when we entered it, we fat fingered it and had the information. So if the date of birth and the social security didn't match, those individuals would get kicked out and they couldn't register, so they were calling the medical board. We'd have to fix their record and then they could go back in and register. But as far as the Cures 2.0 and the alerts, I haven't had any complaints on it working on that end to do patient activity reports or anything on that venue. I haven't had any complaints complaints from physicians. I know the statistics, I think I just got in the month of from June 25th to July 25th, I think physicians had requested almost 150 patient activity reports. So they're definitely, I mean, if we looked at this number probably compared to a year ago, I don't know a percentage, but it's got to be a drop in the bucket compared to that number.
You're saying it's up or down over the last?
Up,
Yeah,
hugely
right,
up. I mean,
right.
because I think when we first started looking, and Ginny might remember more than I do, but I think there were like 12,000 licensees when we first started the whole CURES registration of physicians that were registered in the system compared to now, 71,000 plus.
Will there be any effort to reconcile, since they're all supposed to be in as of July the 1st, do you get any kind of a list to check against yours?
Yeah, that's what we're working on right now with the Department of Justice, because for our individuals, I think it might be a little bit easier for us, or more difficult, I'm not sure, I'd have to ask.
More difficult
More
for you.
difficult for us, because it's not just that they have a license and have to be registered, they have to be authorized to prescribe, which means they also have to have a DEA. And we don't keep that information, but we've actually found out that through the Department of Justice, we're going to be able to identify who has a DEA, and then be able to identify those that haven't registered.
And I do have a subscriber alert to your board, and I see that you have a lot of physicians now, they being placed on probation and suspension and all kind of stuff. Now, besides that, do you have a newsletter or anything you send out to notify the other good people that what's happening out here?
We do a quarterly newsletter that goes out. So you must be subscribed to the disciplinary
Is it
alerts. If
just-
you go in and subscribe to our newsletter or publications, you'll get those on a quarterly basis as well. And we've done a lot of outreach in our newsletter on CURES. And actually, I would really recommend, we actually received a letter. This is not part of my report, but just thinking about it. We received a letter from a physician's wife, actually, it was in the latter part of last year now, who really put it kind of in the face, and we wrote an article through the patient's eyes, and it really talks about how an individual, she was a mother, and in probably, I can't remember the span, in a couple years, she had received enough prescriptions that people wanted to write her for Vicodin to give lots of individuals Vicodin. And so we wrote the article, we used her letter to actually write the article, and it's a very touching article because it's coming from the heart of a patient who knows the medical side as well because she's a physician's wife, and so I'd recommend you read it. I believe it was in our our spring newsletter. It's our leading article.
Yeah, so there are a lot of physicians there, they are having problems. So I really want to commend you guys and your board. You have done such a good job because I've never seen so many physicians in trouble than before. And they should be.
On what
because-
side you
yeah.
sit on, is that's a good or bad thing?
It is good because they've been out there. They were the one. People were blaming the pharmacists, but the physicians were the one that really need to be taken care of first. Thank you.
I want to make a comment that we really appreciate that you're coming over, and I'm very happy that we're working together, the medical board and the pharmacy board. I thought I would never see that in my lifetime, and I'm very happy that you guys tackle all this difficult problem together. Thank you.
I couldn't have a better partner to work with than Ms. Harold and Ms. Sodergren.
Thank you, likewise.
Thanks, Kim. We appreciate the collaboration.
Thank
Thanks
you,
for
Kim.
coming and your patience.
Thank you.
Okay, you want to go back to the licensing committee?
I didn't think we
Stan?
talked about it enough.
Well, did you have an issue?
I have one quick
Jenny?
issue before we leave the issue. I thought you were talking to me until you threw Stan in at the end of the sentence. Given that our notice period, we clock 1 year on the CE reg in September, I think that if we do a 15-day comment period and not bifurcate the regs, we're going to end up having to start over anyway. So can I ask the board to answer one question? I recognize I'm creating a potential problem here. Can we bifurcate the reg and pull out the dedicated CE element into a new reg, notice that, and move forward on that? Meanwhile, we can go ahead and finalize the rest of the reg. Laura, your hand's up.
I had the date wrong. When I went upstairs, I double checked it, and it's November is when the 1 year is up.
Never mind.
We're okay?
Yep. Thank you. Yeah, that September
was
date had me
easy as
worried. November, we should be fine.
Okay, thank you. Stan?
Okay, so don't shoot the girl, but I wouldn't be totally opposed to bifurcating the reg and taking that 2 hours and sending it back to licensing to really kind of iron it out, but probably everyone's going to shoot me because we've kind of talked about this enough, but I'm going to just kind of float it out there if we want
Was that a motion?
to, only if I can get a second.
No, I'm going to second Debbie's motion. I actually agree with you. I think it should be well thought out, and we should really do some consideration of the options.
Okay, so that was a motion and a second?
Yeah.
What was the motion?
Any board?
So
What,
to.
what was the motion?
To break up the CE, because you know how there's actually 3 sections to it? There's 1732.05, 1732.2, and 1732.5.
Right.
But to break it up and take 1732.5, pull it out, move the other 2 pieces forward.
Yeah, that's
The
fine.
part that we pull out, which is what we voted on,
Exactly.
to send that back to licensing to really review it. And I'll tell you, I have a little bit of an ulterior motive. I'm still on the fence whether we want to make it mandatory. And so I think we
No, we already
absolutely want
voted
to.
do it.
Yeah.
We already
We
voted to do
voted to
it.
mandatory.
I don't wanna go
Well,
back.
I'm saying we send it back to licensing to consider, but,
I don't want to send it back. We already passed
Yeah.
it.
Why was
okay.
it-
Well, I
Well,
think
we-
it's
we
a
have a
mo-
motion.
That's why we have motions, Greg. We have a motion.
down.
Yeah, because every time you send it back, you delay the process further and further. I mean, our job here is to cut the government red tape and do things efficiently. That's why we are appointed for.
I just want to make sure we do things right.
We always do it right. We do it right and do it efficient, Debbie, okay? As opposed to do it right and do it slow. That's 2 different kind of people.
Okay, any public comment regarding the pending motion? Okay, all those in favor, raise your hand, please.
1, 2.
Okay, motion does not pass.
Want to get the rest of the vote or not?
Oh, all those opposed? Okay,
Okay.
all right, Stan, licensing.
Okay. Moving along. Consideration of ownership structures for pharmacies, including a summary of a presentation by the Office of Attorney General regarding trusts and possible next steps. So the board tracks the beneficial interest of business owners for pharmacies, whether they are natural persons or entities. Board regulation specifies the reporting of a transfer and the beneficial interest in the business and specifies the threshold as to when a change of ownership must be submitted to the board. And to quote Business and Professional Code 4035, what a person is, a person includes a firm, an association, a partnership, a corporation, an LLC, a state governmental agency, or a political subdivision, not a trust. It's silent on a trust. So as the committee was advised during the last committee meeting, when processing a pharmacy application, the board identifies and records all levels of ownership of the applicant business. This is done through a careful analysis of all information submitted in support of the application and oftentimes identifies inconsistencies with respect to the ownership reported. For some, what is initially reported as, and what appears to be, a simple 2 or 3 level ownership structure, when staff uncovers details, it often turns out to be multiple levels of ownership and multiple stakeholders. It is common for applicants with complex ownership structures to argue that the board doesn't need to know all of the information related to a pharmacy's ownership. Board staff has identified where either revocable or irrevocable trusts is or are reported as owners of an applicant business. Pharmacy law does not currently recognize a trust as a person, as I said, to which the board is authorized to issue a license. However, in researching older licensing records, some trusts have been found to be on record as shareholders of existing licensees. During the board meeting, the board was advised that as with other ownership structures, trusts can be used as a legitimate form of ownership. However, they can be manipulated to hide ownership. So the committee's discussion and recommendation. We heard from Matthew Hine, a deputy DA, and a very nice, bright fellow, by the way. He discussed that one of the challenges currently facing the board is hidden ownership of applicant business. He referenced the Panama Papers that detailed 2 foreign-owned pharmacies held by trusts that ultimately allowed them to exert monopoly control using their... Mr. Hine confirmed his belief that the board does not currently have the authority to issue a license to a trust owner, and indicated the board will need to identify what information should be collected as part of the application if it chooses to allow such ownership. The committee heard information from the public that offered different opinions on what the law currently provides, and the committee noted the important role a trust plays in estate planning. I just want to mention before I end that on attachment 4, there are the letters from Desiree, who's with the Attorney General's office, and the letter from NAC. Both very interesting in different points. So it was a recommendation of the committee to ask legal counsel to review statutes and regulations to propose a fix to resolve the trust issue and how to regulate the entities within the board's regulatory framework. And as I said, attachment 4 has the letters, and attachment 7 are the minutes regarding this meeting and this topic. And I would want to add that part of the discussion was the existing few trusts that are out there as pharmacy, with pharmacy ownership. And so we are working with that. It's with the attorneys, and we don't have any definite information to offer the board at this point, as the attorneys continue to review it and look for a way where both we can deal with the existing trust ownership and what would be the best tack to take as we look to the future in allowing owners to use the trust as an ownership.
Then just basically at the current time, we are getting continual, we're either becoming more proficient at identifying trusts in our structures when we receive ownership information, but it is a very serious issue for our licensing unit right now, how to treat the issues of trusts that wish to own pharmacies, pending a firm and final resolution by the board on this matter. So it's very topical, and it's very frustrating, I'm sure, for our applicants.
Members, any questions? Victor?
So my question is, in the meantime, there might be other people applying for the ownership under the trust issue. Do we have a solutions for them right now, or as we are anticipating a final opinion from our attorney? But otherwise, we'll be holding a lot of applications that we don't know when it's going to be finished.
I don't think you're not waiting for our opinion so much as it is, well, I guess it's the opinion of how to fix it or how to resolve it looking forward. So looking at the statutes and the regulations and sort of coming up with a suggested plan of how, what to follow through on the committee's recommendation, which is they would like to find a way to be able to license trusts in a way that allows the board to track the ownership in a meaningful way.
But in the meantime, can the board still accept application under this statute?
So my advice, and I believe Desiree's and Josh's as well, and I'll let you speak for yourself if you'd like, is that currently under the language of 4035, a person does not include a trust. A person includes other things that are types of business organizations, but it doesn't include a trust. And in the absence of that, there's no statutory authority to issue a trust. Now, as Mr. Weiser mentioned, there are existing trusts out there.
Right.
And I think that falls under the uncomfortable and awkward solution of just because you've done it wrong once before doesn't mean you should continue to do it wrong. So we recognize that that's a very difficult practical implication, and so that's why we're trying to work with the staff to come up with a solution.
And also, how many existing trusts, how many existing licenses that we do have under the trust, and also how many applications are we seeing that they're trying to do under this trust? So we'll know what the ramifications are.
We have in the vicinity of about 75 trusts that we're aware of that are part owners of, or owners of pharmacies. Existing, but that may not be an accurate number because sometimes the trust ownership would be hidden within one of the multi-layers, and we're not sure whether or not that was detected and whether or not our system is able to do that, short of pulling the actual records in a different way. I believe we have at the current time in the vicinity, do you remember, I think it was 15 or 20 apps pending. So that's what I'm saying, we are definitely proficient now in identifying them in a way that we weren't before.
And have we been seeing any problems coming out of that 75 licenses that we had under the trust?
We don't know what we don't know. We don't know whether, we haven't investigated those entities that have trust ownerships to see whether or not they're in fact some kind of nefarious, to use the phrase that we keep seeing in all of the documents on the trust, is the nefarious operations of these licensees. We have not, frankly, looked to see whether or not that there is a potential problem with who they are and whether or not they're even hiding any information from us. But that's part of why we have a number of attorneys working on this issue, because if we find a solution, we want to make sure that it's parallel to what we require other licensees to provide us and keep us advised of. We would want a parallel structure.
But I see the main issue here is just the disclosing of information of the ownership. I think that's what's sticking out to be the main
At
issue.
our committee meeting, as you recall,
Right.
we had Matthew, and we had, Laura, you were there, and then we had the attorney from Quarles and Brady, and it seemed to me that when we have everybody in front of the committee, that we came to kind of a meeting of the minds. And the meeting of the minds were that, as Desiree in her letter suggests, that to amend Title 16, 1709, to require trust to disclose identity of all trustees, beneficiaries, and grantors, etc. So are we at a point where the meeting of the minds that we had achieved at our licensing committee meeting didn't stick?
I don't think that, I still have a problem with 4035. I do think that Desiree's recommendation here is that we recommend the Business and Profession Code Section 4201, which is the application requirements, that be amended as well. I think Desiree, my impression from Desiree and Matt and Josh is that that we all think that there's a statutory element of this as well. I apologize, that was not the impression that I intended to give, is that there was no possible statutory elements of the fix. But that was what we certainly agreed to look at and bring back to the committee. It's in September.
Okay.
Whatever it needs to be.
Okay,
done
well, the
for
committee
fix.
certainly can wait.
The intent is to have a resolution
Is to-
from the legal side of this to bring to the licensing committee in September. The real question, which is what I think we're all kind of talking around in here, is what do we do in the interim to the pending applicants that have applications pending? And I'm hearing a recommendation from our attorneys that it would be better not to add to the problem, but to wait until it's resolved. Did I?
That's my advice, yes.
So,
Kind of a difficult place, though, for us to be in.
I understand.
Right, because this is something like a lot of older pharmacists would want to do. I mean, people like of my age, I mean, who knows when I'm going to kick the bucket the next day, and then you want to leave something in a trust.
you mind waiting until the end of your term, Victor?
Or until we
Maybe,
get
but
this resolved.
But you never know. But if it's just something that got stuck right here in the licensing committee, that I wouldn't even able to defer.
Don't open a trust, Victor.
I
Well,
mean,
what-
and also, I remember seeing that newsletter was instructing, our board newsletter was instructing our licensee how to put your stuff into the trust, your pharmacy license, and that kind of stuff. We were instructing the all the licensees to do something, and now we come and say, oh, we did it wrong, we're not going to do it, hold it up. If we're going to fix it, we have to
That
fix it
happens.
fast. That's what my opinion is.
I hold Josh in the highest regard. I'm sure everybody does. But he wasn't at the meeting. And it was my understanding the person at the meeting, Matthew Hine, was, the top dog when it comes to trust and everything.
Yes.
And so it's great that Josh is involved, but it seems to me that Matthew was okay with what we were.
I did not have that impression.
Oh, really?
I think where we kind of agreed was that we knew that we could work to get to where the committee wanted to be, and where the committee clearly wanted to be is in a place where the board can license trusts.
Is there any distinction between a living trust or a testamentary trust or anything?
That would be an excellent question for Mr. Hine.
Yes.
Okay.
So is he still involved in this?
I think he
He'll
made
be.
himself very available, and he was willing to participate in our suggested fixes for all these matters.
And so is time of the, an issue here? I mean,
Time's very much an issue. A statutory resolution would mean 18 months from now before we could issue a license to a trust. And that's assuming the bill goes through next year. That's assuming the bill goes through and it gets signed by law. So I'm not sure that there's a problem there, but you never know when you go to the legislature what you're likely to find.
can the committee expect an opinion that they can act on at our September 21st meeting?
That,
The intent is to bring the regulatory framework to the licensing committee in September so that the board can take action on it in October, assuming that the recommendation from the board is to pursue statutory change. That gives us time to identify an author and secure the statutory changes next year. I don't know that we would be able to support an urgency provision, but if we could try to request an urgency provision in the legislation that would allow it to take effect a little bit more quickly.
But it's the first year of session, too. It's going to be problematic to even get an urgency bill through real fast. The second year is a little easier on an urgency, but.
Okay.
But
well,
anyway, so before the board, we need to have some guidance here about what you expect from us.
The recommendation from the licensing committee is for council to draft a regulatory framework that will be brought to the next committee and then to the board for consideration.
That's about the best we can do.
regulatory
But are
and
you asking
statutory, I
Jenny, what do we
believe.
do in the interim?
Yeah?
I think what Jenny's asking, though, is what we're going to do in the interim if we have applications that are pending.
I have a question. Are the applications under penalty of perjury? By
Yes.
chance? So there is a little mechanism, if they do commit perjury and our investigators go out and discover this, they can get prosecuted.
It's
So-
an issue, yeah.
I'm just thinking we're not kind of letting them go. I mean, we have individuals with an oversight here, or the subterfuge ownership.
I think to answer your question a little, maybe not directly, but substantially indirectly, I think that one of the things we will do is we will go back, and part of the legislation will require us to remediate and find a way to bring into compliance the additional information we need about who the current owners are of the trusts or who the trustees are that are in charge of these entities, so that we can over time track who owns them in a manner that's comparable, perhaps not equivalent, but comparable to what goes on in the corporate or the LLC world. So I think long-term, we can find the solution. The difficulty is, we've got applicants now that want to do business in the state or have already reformed or are in the process of reorganizing their businesses into this structure, and our law doesn't account for it or accommodate it.
How many do we have? Is it a lot
Figure
or just
100.
a handful?
We know of about in the vicinity of 75 with about another 20 apps pending that we're aware of. There could be additional ones that we just haven't been able to discover it because of the way our computer system is established.
We have,
The name itself would be difficult. We'd have to use the name. You can sort on the word trust, but if the trust isn't in the name, we're going to have a little harder time identifying it.
So you're saying there's 100 pending apps or 100 licensed?
There are 75 actually licensed with the name Trust in their name, so they were easily identifiable. We've got about 20 apps, and there is an untold number that if they're not using the name Trust as part of their name, we don't know who they are. We would have to pull the file documents to look at it. So,
We have the pleasure of somebody who's come a long way to make a presentation. If the board is okay, Madam President, if we could call upon our presenter?
Sorry, I jumped the gun earlier.
That's okay.
So, I did come from near Chicago, where our main pharmacy is located, and just would like to address the board on this issue because I think, and you know, maybe I'm wrong about this, but I think there's two different things going on here, and maybe I just don't understand the way the board's interpreting the law. But I thought in 4035, and actually the provisions that allow for registration of pharmacies in 4112, specifically to non-resident pharmacies, it says that if, you know, a pharmacy that's located outside of the state needs to register with the board before it does so, and it can't act as a non-resident until you've obtained a license. It then says specifically that the board is permitted to register a non-resident pharmacy that is organized as a limited liability company in the state at which it's licensed. So you are permitted, it seems to me, if the entity is organized as an LLC, to register that LLC. What happens below that obviously is important to the board, and I understand that. But it isn't a prohibition to issuing the license itself. You can register an LLC. It clearly says that. There are other provisions, and just so we can be an example, I guess, for the board, we applied in March. There was additional questions that were asked. I think you've detected that there were trusts involved in our ownership structure down the line, and additional information was requested and provided, including grantor, trustee, beneficiaries, all disclosed. The two trusts in our situation are both estate planning tools that were used by the owners in connection with the ownership of a company. So it's all been disclosed, and actually I think the board also has the authority to ask for that information, because in 4207D, it says, notwithstanding any other provision of the law, the board may request any information it deems necessary to complete the application request for information that the board deems necessary in carrying out this section in any application or related form devised by the board. It shall not be required to be adopted by regulation pursuant to the Administrative Procedure Act. So, bottom line is, it seems to me that you can request this information already of the ownership structure all the way down to the beneficiaries of a trust that may be in the ownership structure there somewhere. I do think that there are nefarious people out there. There are a lot of people that organize entities for bad purposes. That would include, limited liability companies, corporations, and partnerships. And then one other just small point is, I think one of the issues is tracking the ownership of, a corporation and a limited liability company somehow seems a bit easier, but the section that defines person refers to a firm or association. I can almost not think of anything that's more sort of loosey-goosey than that. What is an association? What is a firm? And the board's permitted to issue a license to an applicant that's actually organized that way. So from our perspective anyways, I believe that the board has the authority to issue a license to an LLC. Our company is an LLC. You have the right to request the information concerning our ownership structure. You've done that. It's been disclosed. I just think you can move on this, notwithstanding the idea that you need to address your regulations and statutes and make sure that trust can actually be in ownership of a pharmacy if that's what you decide.
I can't hear you.
Have it, you know. So I think we've heard this from the other presenters as well, the same argument. And the problem is that our position, and I think I speak for Matt and Josh and Desiree as well on this, is that if it's prohibited at a different level, excuse me, if it's prohibited at one level, you can't have it at a different level. So I understand what you're saying, which is that you're not technically you're not issuing the license in the name of a trust, and that's the argument, that we're not issuing the license to a trust because the trust isn't the direct owner. But if the LLC is wholly owned by a complete trust, then all you've done is created a loophole and sort of.
What if it's
perverted the
partially
meaning
owned by a
of the-
trust?
I'm sorry?
What if it's partially owned by a trust?
But the problem is the analysis still holds, which is our legal analysis is that the trust is not one of those enumerated entities. That list of entities that's described under person is very specific, and it's not included but not limited to. It's a list of very specific types of entities, and apparently at one point there was a version of a trust included, and that was amended out. So given that, we have a hard time believing that a prohibition, for the same reason that you would also prohibit a person who owned a trust who had a disqualifying characteristic from being not the immediate licensee, but maybe the owner, so the LLC that's owned by the former pharmacist who's been revoked, or by the doctor who also can't, hold, then we also prohibit that ownership all the way up. The same criteria that would invalidate the ownership at the title level, for lack of a better term, I'm not sure how to describe that, would also prohibit the ownership at one of the non-named levels. So I hear the argument. I'm not persuaded by it. But that's why we have lots of lawyers.
Except that, and I understand what you're saying, except that I think, isn't it different that an LLC is specifically in the regulation that allows for a non-resident pharmacy, or a resident pharmacy for that matter, to be registered, that it uses that, there's a specific sentence in there that says limited liability companies are permitted to be registered. So from that perspective, it seems to me it's the registrant that you're very concerned about being a entity that fits within the definition of person, or be a limited liability company. It's the level below that, though, that you have the power to investigate, and that is what that other section, what was it, 4207, deals with. So it allows you to investigate, make sure that there aren't those sort of nefarious people who are involved in the trust, or involved at a lower level, even in an LLC. Look, the registration of an LLC does not require disclosure of the members. You don't know unless you ask. So it's the same thing with a trust, except that, you're identifying the trust.
Right.
So if someone doesn't disclose to you that a trust is involved, then you have no way of knowing that until it's ultimately discovered.
I completely concur, and I believe staff has been very diligent in the last year or two, which is how this issue came to the attention of the board, in asking that very question. It's become a more and more common, and more, as they've developed skills in asking those questions, I think, right? So I think that we are asking the questions, but I don't think, I hear what you're saying, I'm just not convinced. So I respectfully disagree.
Okay, thank you.
Good afternoon, Brian Warren with the California Pharmacists Association. I think this has been a very interesting conversation for those non-attorneys of us. We've had We've had some very enlightening conversations. I feel like we've gone through a little bit of trust and estates law school classes practically during some of the last couple of meetings. And I think that, there's valid arguments on both sides of whether or not trusts are currently within the definition or not. But one thing that this board in previous discussions, as well as the licensing committee at the discussion last month, seem to be in concurrence on, and correct me if I'm wrong, is that trusts should probably be allowed, whether it's in the statute today or not, as long as the board has the correct information. If the board can agree on that today, then there is a bill currently in the legislature, SB 1193, one that your executive officer and I have been talking about a lot lately, that relates to this board's sunset extension. And I think there's a very good chance that you could just have a quick amendment put in there to add the word trust into that section to settle the argument once and for all that it is allowed. And then the board could, from that point on, either pursue additional regulations about the specific additional information that is sought, that the board believes is needed, or I think, and you have to consult with your attorneys, perhaps, as the last gentleman mentioned, your authority to request any other additional information might even cover that already. But the benefit of this is that it doesn't have to wait until 2018 due to a bill in 2017. We can get this completed by January 2017, hopefully, so that those pharmacies that are in limbo and that do have some type of big fat question mark above their head as far as issuance of a new license or renewal of their existing license, to make life easier on them for pharmacies that have not been in any trouble, that have not been less than forthcoming about anything, but that are just kind of caught in this question of, oh, well, gee, maybe we shouldn't have been issuing these licenses in the first place. So I think that there's a solution that if the board can at least agree on, perhaps we do think this should be allowed. Let's take a step that there's a pathway for this to be done this year.
First one to speak. I was going to let the board go. I think at the end of the day, I don't know, Laura, how one of the things that I would want to do is, in order to assure that we have comparable information, build in, if we were to do this, build in a 2-year period within which the board would have the opportunity to go back and work with the identified trusts to have them provide us with the appropriate information and a tracking mechanism. But this is up to the attorneys. This, to me, is a very straightforward legal issue and not one that a layperson should be involved in. Mr. Warren's correct. We do have a vehicle that we could place the amendment in. I think that if there was general support and no opposition to it, we would have a potential to get it through the process. But what's incumbent on that, I think, for the board, is to make sure that our attorneys are positioned to, besides amending potentially 4035, and I don't know what other code sections, but I think we clearly need to look at that and then build in some kind of period by which we go back through our licensing records to make sure that we've got the appropriate information on everyone. So above and foremost, we've got equal information on all entities in front of us and not just on some. I don't know whether or not that's feasible. So to me, it's up to the attorneys whether or not we can do that. Although I hadn't thought of, I just figured it was too late in the year, but you're right. There is a potential there.
So how much time do we have to do something like this?
Like about 3 or 4 days.
But
Maybe.
I do believe that the board would have to make, if this were to go into that bill this year, the board would have to make a decision today.
Yeah.
Well, Laura, what do you think?
I think it would take that we we will reprioritize. I mean, I think we can come up with some language. It's the definition of person, and it's also, I told you would have the section available. It's 4302 that we probably have to work on as well. But I think we could come up with something that would, get it, at least open the door.
Or what you're telling me, and I'm not sure what you're telling me, are you saying that this is a viable opportunity to add it onto the bill that Brian is referring to?
Is it a possibility? Yes.
So is it something that we should act on? Is it something that we should discuss and act on today?
Yes. You know what I would like to do, and is if it's, would you be willing to maybe table this particular item and we could talk about it after lunch, and then I can look at it a little bit more, look at which sections we need to work on and how much writing we would have to do?
It's fine with me. I'm not going to be here after lunch,
Okay.
but it's
We'll let
fine
you
with
know.
me. Yeah. Madam President, is that?
Yeah, that's a great, that way we'll give Laura an opportunity to review it.
Yeah.
Okay.
And this would resolve this issue without a huge delay and people hanging there, not knowing.
Agreed. Especially if we've got all these applications pending, yeah.
Well, it's, we don't want to make it more difficult for people to do business. We just want to make sure that we have the information we need to make a thorough licensing decision, and we'll be kept apprised of what could happen to those players in that trust down the road. So as long as we find a way to do that, but I do think that there's a couple of attorneys in the southern end of the state we need to speak with.
Okay.
So by saying that,
We'll just revisit it this afternoon and see if we can.
and are you going to, would it be advantageous for you to have Brian's input directly?
Have Brian's input?
Yeah.
Start writing law, Brian.
I mean, you know which bill this is, and it,
We know.
Okay.
Yeah, we know,
Yeah.
we know what to do there.
Stan, do you need a motion or?
No, we're going to wait till
We're gonna wait
after
until-
lunch. Laura's going to do some research, and then we'll get back to us. We can consider it this afternoon.
Okay.
And I can also check in, and I wouldn't want to propose those changes without at least trying to reach out to Matt Hein and Desiree, just to give them the chance. I don't know if they're available or not, but just because they have
Christina, do you have
done
any?
specific work on that.
Well, so my preliminary question to the board would be sort of a policy direction, because from an enforcement standpoint, it doesn't matter so much what the board decides, we just enforce what they decide, right? So if the legislation changes, we'll enforce that. That's not a problem. The question is, do you want it to change? I mean, I think that's something that we haven't, it sounds like the licensing committee talked about that and maybe is in agreement, but I don't know that the whole board understands that, knows what that is, and is in agreement.
What are the downfalls in terms of moving forward? What are cautions that you would advise?
Well, there's a couple things, and I think Matt covered it, although I wasn't here, but I think Matt covered that pretty well from what I've read, which is that it's a lot harder to identify who is a beneficiary of a trust, who benefits in any way. There's a trustee, a beneficiary, a grantor, a settlor. There's several different types of people depending on the type of trust. So just from an idea of, who are these people, that's going to be a concern. So that's one just very preliminary issue. It's going to cause a lot of staff time. We're going to really have to dial down on some of these issues to figure out who are these people, are they people that can be licensed? I think it's doable, but it's going to take even more time than it already takes now for somebody to get licensed if they have a trust involved as well. But as long as, we're aware of that and that is an issue that we're willing to deal with, we can deal with that. The second issue is that sometimes the beneficiaries of a trust are somewhat difficult to discern because they can be dependent on other factors. So that's something we'd have to look at in our regulations and saying, okay, but if this happens, we may have to look at the entire trust document, which could be very difficult for our staff to analyze a trust document when they're not a trust attorney. I don't know that I could analyze a trust document. I certainly couldn't as well as Matt Hein at this point, although if you start sending me enforcement cases, I'll get better at it. The third issue is that some of the people that are identified as beneficiaries in trust, you may not want to do background checks on. They may be minors. They may be, particularly minors. That's the big category of people that I can see. Are you going to have to identify that in your trust you have a 2-year-old child? Okay, so now what are you going to do with that 2-year-old child? You running a background check on them? That logically, I don't see how that makes sense. But if the pharmacy stays in business, at some point that 2-year-old is going to be a 22-year-old. And so are we going to have to rerun a background check when they turn 18 or when they turn 25? I mean, are we going to deal with some of those issues today?
So at our licensing committee meeting, the licensing committee's will was that staff and attorneys look for ways that trust will still be an opportunity for pharmacists and pharmacy owners with regards to ownership, if you want to call it that, and with regards to estate planning. So, and correct me if I'm wrong, you were there, Laura. So I don't think, the will of the committee was that this is something that we feel should remain in place,
Come in place.
or should become in place, right?
From a policy standpoint,
So
right.
where we are is,
So to add trust,
what?
to add trust into that
Well,
definition.
to add trust,
Okay.
or at least trust with provisions, such as Desiree outlined in her letter. And that seemed to be reasonable. And it seems to me an LLC or a corporation, a Delaware corporation, I mean, you could go through any form of ownership other than a sole proprietor and find ways that they can be circumvented as far as, I'm not an attorney. So if the will of the licensing committee is that this is something that we feel should be an opportunity for pharmacy owners, then are we muddling it, or are we making an issue, are we solving a problem that may not exist? I mean, to hear you respond is if we're going to have to check with a bunch of attorneys, and we're going to have to worry about 2-year-olds and all, and something that we're not going to be able to deal with,
Right.
like at this meeting.
Right.
Or soon enough to where it's going to benefit.
Right.
No, what I wanted you to understand is some of the challenges and the regulation changes that may have to come up. If the will of the entire board is, let's amend this, let's add the word trust, I think that, that's something that we can absolutely work on, and that's something that we can accomplish
That's
fairly
one
quickly.
piece, yeah.
And that's the first piece. But my question really was more, is this the will of the board? You're saying it is.
Well, no, I said it was the
Have a
will of the
motion?
committee.
It's the will of the committee.
We've already tried the will of the
And actually, you know what? And so I think you brought up a really good point, and I sort of skipped over it. The board certainly could act on the committee's motion or the committee's recommendation and table the issue that Mr. Warren has raised for the afternoon, which is, okay, now do we want to try to direct staff to see if we can amend 1193 to create an option?
I would leave that to the wisdom of the board.
You want to take a vote?
If somebody wants to make a motion, or,
I make a motion that the board accept the recommendation of the licensing committee.
okay, so, but what the recommendation is, Laura, would you repeat what the recommendation is?
So, I'm going to find the note in your chair.
I mean, I've got this here. Oh, is that what we're looking for?
Language in the chair report, yeah. That's
Well,
where
I
the
got it
recommendation
someplace.
is.
Ask legal counsel to review statutes and regulations. That's not,
I think we need a better.
I mean, do you
Yeah.
want to do like what Desiree said? That she recommends
well, that was
these-
what we had talked about a lot.
the Business
that's-
Professions Code be
Attachment
amended to
4.
require tests to disclose the identity of all trustees, beneficiaries, and grantors of a trust, and deem trustees, beneficiaries, and grantors to hold a beneficial interest in the assets of the trust, triggering disclosure whenever there's a change of any amount of beneficial interest.
So we can't just slip this into the legislation you're talking about. I mean, how do we accommodate that?
First, and then you can augment. Brian, are you okay with that? We can draft language. It would have to go through Leg Council, and they would modify it and massage it a little bit anyway. But then, what I think we would have, based on what I've just heard from our two attorneys, we're going to have to do potentially a regulation in addition to further refine some of the specificity, so that we could do that. But again, I think what we need to do first, before we even get a motion here, is there a general will that the staff explore this afternoon and bring something back to the board before the end of the day? Can we agree on that without even a motion?
Yeah.
And then let us see what our attorneys, I want to give our attorneys pretty much a blank
okay?
slate to draft something so that it's sufficient to go into the statute. We may want to have the board directed develop further regs in order to get at some of these core concepts involving the trustee or some of the beneficial ownerships. And I think the other thing that I might want to suggest is that we might want to determine whether or not we want the trust to be in that first line ownership position over any pharmacy. That it could be part of the structure further up, but that first line owner cannot be a trust. Or whether or not that's advisable, or do that in regs. I mean, maybe that's something for a reg. I'm not sure I'm positioned here to opine where that needs to go. I think we've got to develop a framework that's specific enough to give the board some authority to operate here, but then also to allow the board to refine the regulation a little bit further down the road, allowing more public participation and deliberation. I'm sorry, no, you're.
I have nothing to add to that. I mean, yeah, I think that that's what we're advocating for, is that you clarify that you have the authority and work out the details afterwards.
Planning on being here this afternoon as well?
Yes.
One of us has to be here. No, I'm kidding, I'm kidding. Victor is the vice chair of the committee.
We'll talk about it right after the Ledge Reg Committee.
Okay, so do we need any, we don't need a motion or anything? We've got a meeting of the minds? Yeah, yeah.
Yeah.
Nobody is saying we don't want trusts to be owners in one form or another of a pharmacy.
Correct?
So,
Okay.
Any other public comment?
I think we have more. Thank you, Brian.
Thanks, Brian.
Good afternoon.
Oh, my, yes.
My name's Peter Grigorovic. I'm a partner with FMG Pharmacy Law out of San Diego. Sure. Peter Grigorovic, FMG Pharmacy Law out of San Diego, and this topic has come to my attention through a couple of my clients with pending applications. And I understand the dynamics and the concerns, but what the board's attorneys, I haven't heard touch on yet, whether it be in Desiree's letter or any conversation I've had with Josh, is the distinctions among, what the gentleman over there said, the types of trusts, which are revocable and irrevocable, and who owns the property in the trust. And I think for the attorneys, and I don't know if you could deal with it over an hour lunch break or not, but the California Supreme Court provides real good guidance, and other statutes do too, so when you apply equal protection of the laws, you have to think broader than just our pharmacy applications. You have to be consistent. So if it's a revocable living trust, which I would venture to say most community pharmacy owners have for estate plannings, and those are the ones that might be hanging up applications. I know 2 of my clients have been hung up for months, saying wait until the board figures it out. California Supreme Court said that the property held in the trust, the trustor or settlor, the person creating the trust, retains full ownership and control over that property. So, for example, a corporation have a pharmacy license. Shareholder in the corporation could be a trust, and you want to track the beneficial interest of that shareholder. You want to go downstream. So, for example, in a pending application where they've provided an individual affidavit for that trustor, the trust agreement, live scan for fingerprints, shares, the stock ledger showing the transfer from that individual to that individual's trust. The paper trail has been documented, and in my instance, my client's instance, the change of ownership is only coming about because one shareholder has retired, and we were required to inform the board of the change of ownership because the percentages changed. So now we're in a quandary that we've had an application pending since last year with no resolution. So when the attorneys are looking at this, I think you have to look at it on certain levels, and I don't want to get too legal, but you have to look at it as to, is the applicant a trust? Right now, as the law stands, I would agree with Josh and Desiree and the other attorneys. It's not in the code section, and they don't qualify as a firm or an association. You could find case law on what those are. A trust is not that. And the reason why I say that is because If it's a revocable trust, under the tax laws, IRS, California Revenue and Tax Code, the property in the trust is taxed to the individual. It retains it's the property of the individual. Under the probate code, if it's a revocable trust, a creditor can go after the property in the trust to get the property of the individual. So it's a different animal, a different entity than an irrevocable trust, where there you may need to look at who is the trustee and who is the beneficiary, because the beneficiaries there hold the beneficial interest. So it's a complex issue, I understand that. But we have to be pragmatic about this. We can't talk about it for months and months and months when the board says we got at least 20 applications pending. Fortunately, I guess for my clients, it's a change in ownership only on percentages, but what if it's an applicant who wants to purchase a pharmacy, and now you have a business deal that could be from several hundreds of thousands to 7 figures, and they're hung up. So I think we have to help the public continue to have good care through pharmacies where the board does acknowledge we should allow pharmacies and pharmacists who owns pharmacies to do their estate planning consistent with the laws of the state. Even as recent as fall 2015, the Script had an article in there about estate planning for pharmacies, and in their hypothetical, addressed a trust owning a pharmacy. I don't know if they actually meant to say that, given the statutory language of a person, but it at least acknowledges we're all thinking that a trust in some form, and I suggest it's the revocable form because that's the easiest one to track your beneficial interest, can be either a shareholder in a corporation or a member in an LLC as the law provides for them to be. But I don't know if it's an answer you'll have in an hour. I doubt it will. But I hope that's guidance for the board to at least deal with the pending applications that should be approved, so long as the applicant has provided all of the documentation that the board's requested, such as the trust agreement, the transfer, the stock ledgers, so you know really who owns the shares. And an individual personal applicant should be able to have his shares held in trust as an estate planning mechanism in a revocable trust. So I'd ask you to consider that as you take your lunch break, and then we'll hear back. And the complex issue, and you're going to have dozens of attorneys with dozens of opinions, and I'm sure the board's attorneys will, I know Desiree, I know Josh, and I know that they're smart, but it's a complex issue, and for those who aren't specializing in the area of trusts, it's not something you could really just look at your horn books or look at your practice guides and come up with a very easy answer.
Thank you. Good afternoon, Tony.
Good afternoon, Tony Park. I'm one of those rare pharmacist attorneys. I'm speaking on behalf of, I guess, myself as a practicing attorney, representing a lot of clients that are kind of caught in this quandary that we've been talking about for quite some time now. And I just wanted to kind of remind the Board of Pharmacy that there are ways to change ownership without necessarily disclosing to the Board of Pharmacy. And I'm just kind of giving you an insight. I know, shocking. But just to kind of give you some awareness of what's going on out there. Because when people come to me, and perhaps I have a bias on the type of people that are attracted to me, that they want to avoid problems with the Board of Pharmacy, obviously, and they want to be in compliance. But because of this whole, pending, purgatory situation, the status of this, whether or not trusts are going to be acceptable or not to the board, people are coming up with some rather creative business strategies. One of them being they'll have a corporation set up the ownership, and then they'll basically use the licensure rule that says that anything that has a less than a 10% change of ownership doesn't need to be disclosed at all. Likewise, if there's a 10 to 49%, you don't need to get permission from the board. You just need to notify them via change of permit. So, people I'm glad to hear that the board seems to be on board excuse the pun, with this whole notion of allowing trusts. That's very encouraging. But, know that people's lives are very much impacted here. Just know that there are ways to kind of impose trust, if you will. Just not too long ago, I think the Board of Pharmacy's License Division, they probably know me on a first name basis now, but we've amply disclosed trust documents themselves that are fairly good and detailed insofar as who the trustees are and all the relevant players are. It may take boxes upon boxes of documents to get that information out there, but it is definitely doable. And to your licensing division's credit, they've done a really good job so far. So anyway, that's all I wanted to say. Thank you.
Thanks, Tony. Any other public comment?
Hello again, John Roth, CPHA. Also, as my colleague, as a non-attorney, I understand as well that this is an extremely complex issue, and credit to all the attorneys who are working hard on this, either through the board, DOJ, or in private practice. But there is a reality I just want to implore the board to keep in mind, and that is that your core mission, serving the public. I got a call last week from a pharmacy in Reading, and that pharmacy is one of the 20 in limbo, 20 and growing in limbo. And there's not another pharmacy for many miles around. So those patients are actually not able to get their pharmacy services met because this license can't get transferred. And all this pharmacy is looking to do is move literally from one door to the next door within their building. They have payroll at stake, they have their patients at stake, they are now paying rent in 2 locations because the other owners can't move into that space because they can't move out and get their new license. So beyond the technicalities, as you think about this over lunch and think about what are those interim strategies that you might be able to deploy today to move and feel comfortable that the board has the authority to issue some sort of interim or authorized license to those 20 and growing number, there are patients at stake. And so I just want to remind us all that that's an important component to the discussion.
Thanks, John.
Thanks, John.
Steve Gray speaking as an individual. It's amazing how many times we've talked about this and how many people are watching over the WebEx and are sending me questions about what ifs and so forth. And the thing I remember is that in law school I hated wills and trusts because my mind just got boggled down. But one of the questions that will need to be considered eventually, and I don't want to leave it out, there are differences in the current law about disclosure of people that are involved with a pharmacy if it's a not-for-profit corporation. And as I understand it, a trust can grant a certain amount of ownership to a not-for-profit organization. And then then nobody is a shareholder, and 4203 doesn't necessarily applies only to shareholders, and there are no shareholders and all of that. So again, the second thing that was pointed out is that because of confusion about how far you're going to go in looking at investigating the trustees. As Tony just mentioned, there can be multiple trustees to a trust. As I understand it, a corporation can be a trustee. You can name the Bank of America as the trustee for your trust because they're going to be an ongoing entity.
We usually name the trust department.
Yeah, and so it gets, and then the beneficiaries, as we mentioned, as I understand it, there are trusts set up where the beneficiaries are kept private. In other words, the beneficiary doesn't even know that they're a beneficiary until the event would cause them to receive some of the benefit, I guess. So all of these are complicating factors, and you're going to have to look at them. And so as John Roth just said, it's holding people up for what they want to do, but it's also confusing people of whether they want to be a trustee or whether they want to make somebody a beneficiary if their whole life's going to be investigated just because, of all of that. So again, it's complex. I don't know if you can get anything done this legislative session. I understand the will of the board may be to go ahead, but I think you've got a lot of work ahead of you from a regulatory or just an education point of view now that we've opened up the box. Thanks.
Thanks, Steve. Any other public comment? Okay, we'll deal with this then.
Can I
after
ask a
lunch.
question before we go? Are we going to go to lunch after this?
I'm going to finish my report.
Yes.
But on this point?
Go ahead, Ramon.
Okay. So the point of knowing who owns a drugstore is so that if ultimately there's a problem, we know who we're supposed to be holding accountable, right? I mean, that's what this is all coming down to.
And who would benefit from the ownership? For example, if you are a physician, there's specific bars that you would somehow benefit by owning a pharmacy, and indirectly, you could benefit. There also are people that we do not want in charge or to have a benefit from operating a pharmacy based on their criminal backgrounds.
Right. So the murkier it gets, the harder it is for us to hold people accountable.
Well, that's one of our concerns, yes.
You'd iterate that before lunch.
Dan, you want to finish up the
My pleasure.
licensing report?
Quite a report. So we're down to licensing statistics for those who are still awake. This might do it for you.
No one would be sleeping through
The board received 16,423 applications the last fiscal year, including 6,200 pharmacy tech applications, about 2,000 pharmacist license applications, and 754 pharmacy applications. That never ceases to amaze me. But I amaze easily. The board has issued almost 12,000 licenses, including 5,800 pharmacy technician licenses, 1,978 pharmacy licenses, pharmacist licenses, and 671 pharmacy licenses. The board renewed over 64,000 licenses as of the 30th of June, and had 6,097 applications pending. In addition to the annual licensing statistics, a 3-year comparison is also included in the material for board members and everybody else, and it shows that the overall trends for this comparison reveal the following: that 5% decrease in the number of applications received, no significant change in the number of licenses issued, 4% increase in the number of applications pending, 4% increase in the number of licenses renewed, and a 2% growth in overall licensing population of the board. So, the committee discussion was that during the meeting, the committee discussed the licensing statistics for the first 11 months of the year, as well as the current processing times. All the information is available in the attachment number 7. And for another exhilarating licensing committee meeting, hold September 27th available. We're not sure about the location yet. Thank you, Madam President.
Thank you, Stan. All right, so is lunch here? All right, we'll do how about a 30-minute break for lunch? We'll meet back here at 1:30.
Have a wonderful cruise.
Oh, thank you.
With the board meeting, starting out with the Ledge Reg Committee. So I'll turn it over to Chair Lippy.
Thank you. We will begin with board sunset legislation. Copies of each of these bills are provided in attachment 1. The first one is SB 1193. This measure would extend the operations of the California Board of Pharmacy and the board's authority to appoint an executive officer until January 1st, 2021. It would establish the framework for the licensure of outsourcing facilities, would authorize the board to synchronize license renewal dates and aggregate fees for clinics, and would authorize the board to issue a temporary permit for specified licenses, and repeal obsolete provisions related to electronic data transmission prescriptions in the Health and Safety Code. There are some additional changes it would make, technical changes, and we have a support position on that, and the committee does not recommend any change in that position. Are there any comments either from the board or from the public? No. Okay, next, SB 1039. This is, it would set forth a new fee schedule, which is needed to sustain board operations, and committee discussed the measure and does not recommend a change on this. Next would be legislation impacting the practice of pharmacy or the board's jurisdiction. Copies of each of these bills are provided in attachment number 2. The first one is AB 45, related to household hazardous waste. We have an opposed position unless amended, and the measure would have established a process for model guidelines to be created for the disposal of household hazardous waste. However, the committee was just recently advised that the staff believe the measure's dead, and at any rate, it's not going to move this year, so this is just for information purposes. Next would be AB 1069, which would expand the provisions under which a county-established repository and distribution program allows the transfer of drugs to other counties, not just adjacent counties, and would allow for the advanced repackaging of donated medications in advance of a prescription. We have an opposed unless amended position because currently the bill would remove a pharmacist from several aspects of the redistribution program of prescription drugs. It would allow a participating entity to transfer drugs like a distributor without appropriate licensure and control, and would permit what is currently unlawful repackaging and commingling of previously dispensed medications, including donated medications from various sources, all to the detriment of patient safety. Any comments? Board, any comments? Public? Nope. Okay. Next is AB 1386.
Sorry, I was talking to council on the
Sure.
trust issue. On AB 1069, I wanted to let you know that it is my understanding that there are going to be amendments, and the language, it looks like it hit my mailbox, my email this morning. I haven't had a chance to look at it, but it's my understanding that there will be amendments that will change significantly the legislation. It will still be dealing with the county redistribution programs. The amendment will be to allow the repackaging of medications in advance of the patient presenting at the farm if it is a pharmacy within the county that specifically only deals with these types of medications serving this specific population.
So, do you anticipate that we would change our position based on that?
Until I've had an opportunity to really look at the language, I don't know that I'm in a very good position to do it. The board does have the policy where I can work, or where board staff can work with the chair of the committee and the board president. So unfortunately, I think that this is one of those that we'll have to work offline on because it's just
Understood.
so breaking.
Okay. But you'll keep me informed. Okay, next, AB 1386, emergency medical care epinephrine auto-injectors. The measure would amend pharmacy law and other provisions. By the way, we have a support position. The measure would amend pharmacy law and other provisions of the Civil Code and Health and Safety Code to authorize a healthcare provider to issue a prescription and a pharmacy to furnish epinephrine auto-injectors to an authorized entity, which would include any for-profit, nonprofit, or government entity or organization that employs at least one person or utilizes at least one volunteer or agent that has voluntarily completed a training course as defined. As is with current law, authorized training providers shall be approved, and the minimum standards for training and the use and administration of epinephrine auto-injectors shall be established and approved by the California Emergency Medical Services Authority. The committee discussed the measure. We're not recommending a change to the board's support position. However, the committee asked the staff to reach out to the author's office to determine if the author would consider allowing a pharmacist to provide the auto-injectors without a prescription. The committee noted that the board may want to consider pursuing legislation to allow a pharmacist to do this without a prescriber order if the current measure is not amended to incorporate this. Next is AB 1748. If anybody has any comments or so on, please come up. No. Since nobody's running up, I'll go on. AB 1748, emergency medical care, naloxone hydrochloride, or other opioid antagonists. We don't currently have a position on this, but we are recommending a support position. The bill would authorize specified educational agencies to provide an emergency opioid antagonist to school nurses or trained personnel, and would authorize a school nurse or trained individual volunteer to administer an opioid antagonist to a person who is believed to be suffering from an opioid overdose. The bill contains provisions that authorize the writing of a prescription by a physician and surgeon and a pharmacist's authority to dispense naloxone hydrochloride or other opioid antagonists pursuant to that prescription. We all know that somebody can walk in and get one of these antagonists from a pharmacy without a prescription, but this is related specifically to educational agencies or entities. The author's office indicated the measures modeled after the provisions regarding the epinephrine auto-injectors. We discussed it. The committee is recommending a support position, and in addition to that, as we recommended with the auto-injectors, that we would ask the author if they're interested in amending the measure to allow pharmacists to provide it directly to the educational agencies without a prescription. That's all we can do is ask them at this point.
So Greg, right now that bill is, because a pharmacist can provide a stock to someone
Individual.
under a physician's oversight, so they can
Yeah,
give
they
drugs.
can do it as long as the physician writes a prescription.
Or requests it.
Requests it. But what we would like to see is that, similar to if you or I went into the pharmacy, we could get this without a prescription. We would like to see, a school nurse to be able to do that too. So that's why we're
Without having to go to a physician to ask.
Yeah, exactly.
Okay. Well, they don't need a prescription, it's just a...
Anyway, so the committee does make a motion to support this bill, since we don't have a position at this point. So are there any?
And I just, because when you said that, did you say that we wanted for the EpiPen, we wanted the nurse to be able to get, we wanted to be able to dispense
Well,
it
the
to
bill-
anybody that
yeah.
came in that seemed appropriate.
The bill says,
The bill's
that
right
you have to
around-
have a prescription.
Right, so the bill's focused around the
Right.
school situation, but we kind of wanted to really broaden it.
We want to
almost-
broaden it, but in the meantime, we're supporting we want to support the bill.
Yep.
So, are there any comments by the board? Comments by the public? Okay. Hi, Steve.
Steve Ray from Kaiser Permanente. I was at the Legislative Committee, as you may remember, and I suggested that we do ask the author to change that. And part of the concern was, first of all, the physician has to make sure that the person has had the training. And it's not a patient relationship. It's quite capable for any pharmacist who can run a pharmacy or operate a pharmacy to ask the person, have you had the training and where's your certificate or whatever is required. So it just doesn't make any sense to me to burden physicians with that responsibility. And in fact, many physicians say the same thing. Why would I want to do this? I can't dispense it. Then I write a prescription, and what do I do with it? I put it in a medical record? I mean, what is this? And so so that was the motivation for us to go. I haven't heard what the author said. Was the author amenable? Okay. And then the second thing is that this raises, back in my old law school days, and I don't even know if, Abraham Lincoln is still around to taught me this, but this raises what we used to call a negative pregnant. If you're saying that the school personnel can only have naloxone if they get a prescription from a physician, does that mean if a teacher or somebody comes in and says, oh, I work at the school, but I do want some naloxone, does that say, oh, no, then I can't give it to you? Because the only way as a teacher that you can get it, or a school nurse, is if you get a prescription from a physician. I mean, it just raises kind of silly questions when the whole idea is for this drug to be in the hands of people who can save lives. And of all the people we'd certainly want to save lives on would be students that overdose or in our schools and so forth when they're not near their parents, they're not necessarily near their friends or anybody else. So I would really encourage us to try to get that quick amendment, or in the alternative, because it's late in the year, just keep in mind, let's do this next year and resolve this kind of issue.
Right.
So that's my input on it. I just wanted to share with the whole board, those were our thoughts. I mean, I've literally had physicians saying, well, I'm not going to write prescription for schools. Why should I do that? Why should I develop a relationship with a school? I'm not in the business of treating schools or school district. I'm in the business of treating patients. And why do I want to get involved in this?
Laura, should I include that in the motion about going to the author, or do we need to do that? Because this is a motion to support the bill, but we also would like to go to the author and see if they'll expand it. So,
Yeah, I think that the committee discussion indicated that the committee is recommending a support position and suggest that, given the ability of pharmacists to provide naloxone, ask the author. So I think it's all included in there. I think it's okay.
It is part of the committee motion, so to speak. Okay. All right, so that's what we're going to vote on. So all those in favor of supporting and asking the author to expand it? Okay.
Unanimous.
100%. Passes. All right, moving on. SB 999. SB 482. SB 482 is the Cures database. The board has a support position on it. Measure would require a prescriber, not a pharmacist, but a prescriber, to access the Cures system under specified conditions, to include checking the system before prescribing a Schedule 2, 3, or 4 medication for the first time, and at least every 4 months. The bill also limits the dispensing of a controlled substance in specified settings to either a 5 or 7 day supply. Committee briefly discussed the measure, doesn't recommend a change in the support position. Are there any comments?
What are the specified settings?
That is in attachment 2, I believe. And specified settings, okay. Find it.
Oh, what were the specified settings that limit the 5 to 7 days?
For the 5 to 7 day supply.
I'll find it. I'll look in here and see.
Ann can look it up. She's not busy.
And also, is there any, Greg, is there any mentioning about the penalty if they don't comply?
I don't see any mention of it, but that's something we can look up too.
And Greg, there was nothing in there about a physician's ability to look up their own controlled substances that they allegedly wrote? Because I know that's what's an issue with some of the physicians. They can't do their own Cures lookup on their own prescriptions.
That I didn't know.
All they can do is do Cures reports based on a patient. So if I
That's
wanted to
interesting.
know all the controlled substances I wrote and I'm a provider, I can't access that data.
Oh, you can't, so you're saying, because I know they can do it on a patient basis.
But not on a provider. So if you wanted to
Ah.
see if you had some diversion going on or something, you could tell.
Yeah, I don't believe that that's a provision in the current bill. But with respect to the 7-day supply, it appears to be in the emergency room of a general acute care hospital if the quantity does not exceed a 7-day supply.
I was too. I was-
Okay.
Yeah.
Supply when ordered, administered, or furnished or dispensed to a patient as part of their treatment for a surgical procedure.
Is there any, in terms of the 5 to 7 days, if it's an emergency department, what if it's a patient that has oncology conditions or they've got serious pain because of an oncology issue?
Not an expert, but I believe that then the provision to not check cures, if they wanted to, my assumption would be if they wanted to dispense a greater quantity, they would need to check the cures. That's just the exemption not to check the cure system before.
Oh, I got it. Okay, so they can
there-
check cures and get more than 5 to 7 days. Got it.
But there's nothing that requires anybody to check cures.
True.
This just requires, I mean, not currently, I guess it's.
Yeah, because the ED quantity dispensing is a common act that a lot of EDs are doing right now, but they do have exceptions for patients that have, like, they're dying of cancer or they've got some
Right.
severe pain issues that you don't want to limit their ability to access
Those are the
either.
people that take the Oxy 80s.
But this requires prescribers to check cures
Right.
on
Yeah, this-
initiating a prescription.
I didn't know that it was a
But
cures
Right now,
issue.
there isn't any requirement.
Right, yeah. And I know other states, just New York and several other states do require it, and they have seen a significant drop in the number of doctor shoppers.
Right now, we
And for looking
require
that up.
them to register for cures, but we don't require them to. What was that?
What was that?
Wow.
Busted, yeah.
It just
okay.
happened, right, Laura? It just turned on.
All right, moving along.
TV while we're on here?
SB 999, contraceptives annual supply. We don't have a position on this. The bill would authorize a pharmacist to dispense prescribed FDA-approved self-administered hormonal contraceptives either as prescribed or at the patient's request in a 12-month supply unless the prescriber specifically indicates no change to quantity. The measure would also require a healthcare service plan or health insurance policy on or after January 1, 2017 to cover a 12-month supply of a self-administered hormonal contraception dispensed at one time by a prescriber or dispenser. As recently amended, the bill incorporates reference to Section 733 of the Business and Profession Code, which is the conscience clause, I think. The board does not have a position on Senate Bill 999, as I said. We are not recommending anything. Comments? Board, any public comment?
Why wouldn't you want to support it?
Because we didn't feel comfortable in having a 12-month supply without being checked, you know.
Yeah, we felt it was kind of more of a benefit design, not really a patient safety thing, so we just thought it wasn't our place.
We felt, you know, we should at least have blood pressure check and stuff like that every once in a while, and not just 12 months worth. Unless you want to make a motion and see how it goes. Okay. Okay, SB 1229, secure drug take-back bins. Senate Bill 1229, as amended, states the legislature's intent to encourage good faith participation of federally authorized entities to maintain secure drug take-back bins for the convenience and public health and safety of prescription drug consumers and for the proper disposal in the waste stream of pharmaceutical waste contained in the bins. The bill incorporates the Secure and Responsible Drug Disposal Act of 2010, and states that the provisions of the bill shall be construed in a manner that is consistent with requirements imposed by the DEA's final rule and any regulations promulgated by the state. The committee has the board has a support position, and the committee's not recommending a change. Comments? No. Next is legislation impacting board operations, and copies of these bills will be found in attachment 3. First one is AB 12, and this bill would require state agencies to review, adopt, amend, or repeal any regulations that are duplicative, overlapping, and inconsistent or out of date, and that this be accomplished by January 1, 2018. And the committee actually the board has an opposed position. We're not making a suggested change to that position. And the reason we're opposing it is really because we don't feel that we can accomplish all that by January 1st of 2018. Comments? Okay. SB 952, pharmacy technician licensure requirements. SB 952 would modify the pharmacy technician licensure requirement to replace the current certification by the PTCB with a pharmacy technician certification program that is accredited by the National Commission for Certifying Agencies that is approved by the board. Staff notes that the measure was inadvertently not included as part of the agenda for Ledge Reg Committee, and as such, we weren't able to discuss it at that meeting. As indicated in the bill analysis, the fiscal estimate of $75,000 for an occupational analysis previously provided to the board has since doubled to $154,000. From information, we got this from information received from the Department's Office of Professional Examination Services. Further, the staff notes that the board will need to develop a regulation to identify which certification programs it wishes to approve. Do we actually have a support position on this? Because we couldn't discuss our Ledge Reg, and I mean, now that...
So the board established a support position, I think it was at the April board meeting.
That's when we thought it was going to be $75,000.
Yeah, so the things that have changed actually is that there's going to be a larger fiscal. We have identified that fiscal and provided that information to the DCA about that change. And we do not, board staff does not believe that that's absorbable within our budget. So if that's the case, the board would pursue, and this legislation is enacted, we will be doing a budget change proposal to request the additional budget authority.
But we don't recommend shifting our position to oppose. We would just try to find the money to make up for it.
So that's the policy part that you guys get to decide. We're just bringing it to you and letting you know how we can secure the additional funding if needed.
So,
and in the additional notes, it says we received information from DCA, Office of Professional Examination Services, that's more like a fiscal impact of $154,000.
right.
Actually, it wasn't a question, it was a statement. It was that we received additional information that's not 75,000, it's actually 154,000.
$154,000.
Impact to the board.
We could not, 75,000 we could absorb, 154,000 we can't. The question is, do we really want to do this?
Well, I guess...
And then go to the budget and try to get a change in the budget to cover it? Or do we want to take a different position on the bill?
You know, Victor, it says that the licensing committee has looked at the different requirements for licensure of a pharmacy technician, and I don't know, have you guys looked at PTCB versus the EXCPT, and And I mean, do you have an opinion?
Given the higher cost, do you still think that we should do?
Well, I mean, I was just curious if
So we did. And in fact, I think that the company came in to testify in front of the committee. There was also a comparison study too from the board and showing that they are kind of equivalent. So I think we were in support of that.
Somebody wants to make a motion to change
The-
it, I'll move on.
Well, I will tell you
Certainly
that I think
support.
I think the fiscal is a little high. I
Uh-huh.
don't think we can redirect it, as Ann had just said, so we're going to do a budget change proposal. But nevertheless, it wasn't our fiscal, it was a fiscal that another unit of the department put on it for the $155,000. And so for that reason, we're going to push back a little bit on the fiscal for what it's worth. But nonetheless, we have to do a budget change proposal, and then everyone gets a shot at reviewing it through the normal budget approval process for legislation. And at that point, there might
But
be
could
some.
get kicked out.
Just because they indicated a cost of $154,000 doesn't mean that that's what the cost is going to be, or that's what will be approved to the
Could be
board.
300,000.
Yeah. It could be, but let's hope not.
It could be 5,000.
Doubt it.
That's
Okay,
more optimistic.
yeah. All right, so no comments. We'll
We
just
leave it support, right?
keep our support position, right?
Looks like there was going to be a public comment, no?
We have a public comment? Did Steve move?
Yes.
Good.
I thought I saw some
Oh, he
movement
went
on
to
the
the
other side of the
ceiling.
post.
Maybe it was too cold where he was sitting.
Okay. Next, SB 1155, military service. We don't currently have a position, so this is an action item. Measure would allow a veteran who is honorably discharged, who served as an active duty member of the California National Guard or the United States Armed Forces, to have one fee waiver for the application for an issuance of one license by one of the boards within the Department of Consumer Affairs. Provisions would go into effect on January 1st, 2018. The most recent amendment specifies information that would constitute satisfactory evidence of being honorably discharged. Well, your discharge papers are going to tell you whether you're honorable or not. So anyway, the committee decided to support this, so our committee's motion is to support. You have any comments? Okay, so
Vote?
we'll have a vote, yeah. All those in favor?
Sorry, emotion.
Yes.
Opposed? I didn't see all of it, so no abstentions, right? Okay. That one passes. Next are, we move into the regulations. First regulation that we're going to discuss.
I think we have public comment.
Oh, did we have a public comment?
On the agenda is subsection D as in David, talks about legislative items for future meeting. The board may discuss other items of regulation in sufficient detail to determine if they need to discuss it more. And I did send something in, I think, regarding a bill that's in there, and I've forgotten the number, and my phone just ran out of battery, so I can't look it up. But it has to do with a bill supported by certified nurse midwives to basically be independent of physician supervision. And I don't know if it's going to pass. I know that there's a lot of people in favor of it. There's a lot of organizations that are against it. I'm not speaking for or against it. But I wanted to point out that in the language of the bill, not only would the certified nurse midwives, who can furnish, they get a furnishing number from the Board of Nursing, just like a nurse practitioner does. And so related to their practice, they can furnish prescription drugs. What they cannot do right now under California law is buy their own supply of prescription drugs. There's nothing in the statute.
Include controlled substance that they can?
In theory, yes. Okay, I don't know of any nurse midwives that use controlled substances, but, you know, I don't practice that profession yet. Okay, just kidding.
AB 1306.
1306,
In case someone wants to look it
thank
up.
you very much. But what it does say in there is that, basically hidden over in their statute, it says regardless of any other law that they can buy and hold and store their own supply of prescription drugs. But then over in the Business and Professions Code and over in the Health and Safety Code, the sections that list to whom prescription drugs can be sold to or ordered by doesn't list certified nurse midwives. So I think it's going to cause confusion, and I just wanted to, again, bring that to the board's attention, because your wholesaler is going to say, well, I'm bound by this Business and Professions Code, and I don't know anything about, the Practice Act for certified nurse midwives, which says they can do it. Likewise with local pharmacies, et cetera, et cetera. So perhaps, based on maybe a feeling at this point whether it's going to be enacted or not, you may want to suggest to the author that they clarify for under 4059, 4059.2, and even the statutes that say that the board has access to their records, which is 4081 and others, that you do continue to have access to their records of acquisition and disposition and for other purposes, because it's kind of hidden in there, and I didn't want, quite frankly, that to come out later, and then we get into all these discussions about whether the pharmacy or the wholesale operation acted legally when they sold those prescription drugs to certified nurse midwives. Now, keep in mind that when they're completely independent of the physicians, they also may be able to get samples from drug companies. They can store these drugs in their home, or if they're visiting, they can take them with them. All of those things, I think, come into play when you think about it. And I just wanted to say that maybe affects a little bit the practice of pharmacy, or at least the duties of a pharmacy and wholesaler about who can order drugs and who we can supply them to.
Steve, what is the status of this bill? Has it been passed?
No, it has not
Where
been
is it
passed.
at?
I don't know the status. Someone was just on the website.
Okay, so we could take a look at that on the next meeting, right, Greg? Yes. Thank you.
Late, probably.
What?
August 1st is next week.
Right.
So,
Okay,
So the board, because of where it is and because of the nature of the agenda, because of where it is, you can't actually take action, but what you can decide is whether or not you think, based on what you know, that it's worth scheduling a meeting. Yes, you can do that under the special meeting authority. You can do it on a 48-hour notice. So that's kind of the nature of the agenda item, is it allows you sort of the flexibility to talk about something to see
we have
whether or
another
not.
special meeting coming up.
Or we could delegate to the board president and the chair of the Ledge Reg Committee an opportunity to provide comments on it.
Well, the board actually can't take action, so, but I believe
The
that
two
is your
individuals.
existing legislative
Policy.
policy, correct?
Mhm.
So
So we
that
can
could
do that?
happen.
Okay.
Yeah.
So, again, do we have another special meeting? I think we do.
We currently don't have a special meeting. We have a
Not in
probate.
time.
That's not to say we're not going to have one. I'm watching the wildfires down south. We may end up with one, although we don't really have to do one anymore. But
Some of these OAL on our
Well,
regulations.
we should consider it.
good
may
point. Yeah,
have
we've got a
one.
bunch of regs that were real close to coming to fruition at the Office of Administrative Law. So anything could happen. We might have a sudden emergency meeting. Sounds like we're conspiring, doesn't it?
If we do, we can add this.
Yep.
That's the plan. If we
What was the
have
bill
an
number?
emergency meeting, we'll have. Okay, otherwise we'll deal with it in the
That's okay.
future.
I'll find Steve something.
Okay. Any other comments before I move on to regulations? All right. The first one, proposed regulation related to advanced practice pharmacists. In July 2015, staff initiated a formal rulemaking related to the licensing requirements for advanced practice pharmacists. At the February 2016 board meeting, the board adopted the final regulation text. The final rulemaking file was submitted to the Office of Administrative Law for final review on June 3rd, 2016. We were advised that the rulemaking could be approved as early as last week. Ann, was it?
Oh, shall I share?
Go ahead. Unfortunately, bad news.
Unfortunately, we have bad news, but the good news is there's a solution. So because of the timing that we were at the edge of our 1-year mark on this rulemaking, when OAL reviewed this reg package, it found some concerns and it actually has disapproved the regulation.
Really?
So what that means, yes, they had 3 concerns. 2 of them were
Before you go too much further, for the board, in your packet that's in front of you,
Oh,
this is under APP number 1. We had copies in the back of the room for those of you in the audience. So, and it's titled Draft 16, Third Modified Text, and you have to look down a little bit to figure out what code section we're talking about.
And this includes the changes, Laura, you're recommending?
correct.
to
So this
comply
is,
with the
so
OAL.
what Ginny's taking you to is the fix.
Okay.
I will tell you what, I won't go into great detail about it. OAL disapproved the regulation over, I had a very healthy discussion with the attorney there, and we agreed to disagree about a particular issue that's probably interesting only to he and I. Basically, they had the ultimate decision-making authority, and they determined that there was enough clarity, ambiguity, specifically about the double dipping. The issue of whether or not you could use an experience, for example, gained under a collaborative practice agreement to also satisfy the criteria related to the residency. And so, as you may recall, at prior board meetings, I had advised that I don't think there's a way to read 4210, the statute, in that manner. And OAL disagreed, that there was the potential, and OAL felt that it created a clarity issue with the regulation. So the language that you have in front of you, the draft third modified text dated July 26th, 2016 in the footer. If you look in purple, you'll see very slight amendments to section 1730.1, and that starts at like the bottom quarter of the page on page 1. And the first thing that we did was we changed the hierarchy. You can see there that the opening sentence is now subdivision A, and then everything else changed. But the significant piece that OAL is requiring is at the very end of that section, which is on page 3 of the packet, and it's the new subdivision B in purple. And it would add this sentence that says, the experience an applicant offers to demonstrate compliance with one of the 3 criteria in subdivision A above may not also be used to satisfy another of the criteria. And that basically memorializes my legal advice to the board, because I don't think there's a way to read 4210 any other way, but OAL felt that analysis had to be reflected in the 4 corners of the regulation.
But they will accept it at this point with that?
Yes, that language, I ran it by the attorney, and he agreed that offered the clarity that he believed it did. There's a couple other little housekeeping things that we have to do too. They said we didn't offer sufficient explanation for why we chose to have a penalty of perjury provision, which is really common in applications. And it's not, what we'll do is simply modify the statement of reasons, explain penalty. It's necessary to have this under penalty of perjury because we need to know that what the applicant is stating is true, and we want them to take it seriously. And also because we have the ability to discipline them if they lie to us or they are dishonest on their application. So it's very important for that to be a very serious document.
I would highly agree with that statement.
Which I think it went assumed, and we just didn't explain it. I don't think they have any concerns with the policy. The other item that they raised was that the 4210 requires, I think, in the collaborative practice or the experience requirement that it be 1 year, and the board specified in the regulation that 1 year was 1,500 hours, which was fine, but they found there a lack of explanation of why we chose 1,500 hours. It's 1,500 hours appears to be consistent with the other provisions within the law relating to intern experience, and it's apparently a pretty standard term, so assuming the board agrees with that, we'll again modify the statement of reasons, and then we'll basically notice that as a document relied on, and that'll take care of that, and the board doesn't need to act. We will need action on this particular language in subdivision B that you see, because that is a substantive change, or at least, it is a substantive change. So the good news is that when OAL disapproves a regulation, it essentially gives you an additional 120 days to fix it. So with their disapproval, which I think was issued earlier the formal disapproval notice came this week, right?
Yeah.
So we'll have 120 days. If the board approves this language, and that's my recommendation, then you can also delegate the authority to your executive officer to make any, or assuming no negative comments, to make, to adopt the regulation and complete the file and make any non-substantive
I'll make
changes.
that
So Laura, we open this up then for 15-day comment?
Correct.
Okay.
Yeah, and if you get a negative comment, then it will have to come back to the board.
And then you'll get that emergency meeting you were looking for.
There we go. Okay, I'll make that motion.
So the motion would be to approve the
change.
draft third modified text, and assuming no negative comments, authorize the executive officer to complete the rulemaking file, and also delegate the authority to her to make any non-substantive or technical changes as may be required to complete the rulemaking file.
I'll second that motion. I'll second Greg's motion.
Okay, do we have any comments from the public? All those in favor of adopting this? Okay, thank you. Moving right along. The next one is proposed regulation related also to advanced practice pharmacists, but this is for the certification programs. At the November 2015 board meeting, the board approved proposed text establishing the certification program criteria for advanced practice pharmacists. At the February 2016 board meeting, the board adopted the final regulation text. The final rulemaking file was submitted to the OAL for final review on June 29, 2016. Committee was advised the OAL has until August 11th to complete its review. Copy of the adopted regulation language is provided in attachment 5. Any comments? Board, public? Next, proposed regulations related to immunizations, vaccinations. July 2015, the board initiated a formal rulemaking to specify the requirements for pharmacists to administer vaccinations. On January 19, 2016, following the completion of a 45-day comment period and 2 15-day comment periods, the board adopted the final regulation text. In June 2016, the board clarified that the protocol should apply to all pharmacists provided immunizations. The board voted to amend the protocol language for clarity and released the amended text for a 15-day comment period. 15-day comment period ended on June 25, 2016, and the board adopted the final regulation text at the July 1, 2016 board meeting. The committee was advised that the rulemaking needs to be at OAL, or needed to be at OAL by July 23rd, 2016. Did we make it?
Yes, it was submitted to OAL on July 14th, and they have until August 25th to complete their review.
Okay, great. Copy of the regulation language is provided in attachment 6. Are there any comments?
August what, Lori?
25th.
Very much.
Okay, next, proposed regulations related to compounding. On May 8th, 2015, the board initiated a formal rulemaking related to compounded drug preparations. On January 19th, 2016, following the completion of several comment periods, the board adopted the final regulation text. The final rulemaking was submitted to the Department of Consumer Affairs for final review on March 10th, 2016. The committee was advised that the rulemaking was referred to the agency for review and that the review by the agency must be completed and forwarded to the OAL by August 3rd. How are we doing on that one?
As far as I know, it's still being reviewed by agency. I don't know.
We're getting close.
Yes.
Okay. Copy of the adopted regulation language is provided in attachment 7. Comments? Next, proposed regulations related to travel medications. At the June 2015 board meeting, the board approved proposed text related to the furnishing of travel medications. At the April 2016 board meeting, the board adopted the final regulation text. The final rulemaking file was submitted to the Department of Consumer Affairs for final review on May 9th, 2016. The committee briefly discussed the item, was advised that the status of the rulemaking remains unchanged. Question would be on this, what's taking so long? Got to the agency on May 9th, now almost August. There's something holding it up.
I have to actually take responsibility for this one. I have it in my office right now, so it's under review, and I keep trying to
What
get
date
to
does it need to be to the OAL by?
Lori, do you know
I
that?
think it's the 2nd or something, isn't it?
Let me double check.
Okay. Hopefully we'll make it. Copy of the adopted regulation language is provided in attachment 8. Comments? Okay. the next-
Travel meds needs to be at OAL by September 24th.
Okay, so we have a little bit of time.
So we'll make all those deadlines though, right? Yeah, because I mean, part of, as I recall, the reason we had this long discussion this morning about the regulation on CE, we had passed something already years ago. It was supposed to have made it to AOL, and we got behind, we didn't make it, so we had to do it over again, and that's how this whole discussion got started. Correct me if I'm wrong, but that's how I remember it.
I don't believe you're accurate.
Okay.
It took us a long time to develop the regs. We got the regs simultaneously with the sterile compounding regs, and it took us just far too long to go through the process. And so we haven't had to renotice anything other than compounding, which we chose to do because we had an issue, but compounding wasn't part of the 493 things. Travel meds is part of SB 493.
Well, it's just my point is that we missed a deadline, and that ended up making things more complicated in the long run.
Maybe because it got sent to AOL instead
Not
of OAL.
not on,
That might have been it. I thought somebody would catch it.
no, actually, we've been real careful in monitoring our time. There was an extension granted in order to file one of them, but that was done by the department because it was still in the departmental review at that point. But we've tried very hard for the last year to move these things as quickly as possible, and the board has cooperated by having multiple meetings, so it just takes a long time. That was my comment from this morning. Once you approve the regulation change this morning, 300 days, the clock is 300 days. So, that's if there's no problem with the rug, so.
And Greg, I'm sorry, we skipped, I just missed asking the questions on the compounding regs. Those are due to OAL by August 3rd. Are we going to meet that?
I asked if we're going to make it, and I was told yes.
That is our goal. I believe agency has been requested to have it returned to us by Friday, the 29th. So if we get it back on Friday, it'll be submitted on Monday.
Where
to
is it
OAL.
right now?
With the agency.
And they're aware of the time.
Okay. All right, we've worked so hard on these regs.
Yes. Okay.
Thank you.
Next is proposed regulations related to the board's disciplinary guidelines. Assume this additional is after the first part. In September 2015, the board initiated a formal rulemaking to amend Title 16 CCR Section 1760 related to the board's disciplinary guidelines. Following the initial comment period, the board at the April 2016 board meeting adopted the final regulation text. Board staff is currently compiling the final rulemaking package to submit for administrative review by the Department of Consumer Affairs and the OAL. We have a motion that is going to be related to this. The event the OAL determines,
Greg, may I just explain a little bit about what was passed out?
please do.
So when we noticed this regulation language in the disciplinary guidelines, we had included for the board and for the public so that they could see from an implementation standpoint, as people have been monitoring our efforts to implement 1441, we had included the cross-references so that you could see from an implementation standpoint how we were complying with 1441. The disciplinary guidelines incorporate by reference the uniform standards themselves. When we noticed the document, we forgot to remove the cross-reference sections. So what was passed out, and there are a few there, is that we believe at the staff level that this is a non-substantive change and that you've already delegated this authority to Jenny to do. However, being risk adverse, out of an abundance of caution, we're bringing it to you to make sure that you are okay. And all we are doing is removing the cross-references to the standards. You have the relevant pages there in red, and you can see the strikeout. So under reporting to the board and notice to employers, really the change is removing standard 3. Just striking that out. We're not changing any of the requirements, anything that is incumbent upon the licensee.
Okay.
Need a motion, Ann?
So I move that we,
Standard 3 and then
Second.
throughout. So
Second, Greg's motion.
okay. Public comment?
do you want to read the motion? Suggested a
Yes.
draft motion.
In the event OAL determines that the deletion of the cross-references to the specific uniform standard is a substantive change, the board adopts such change, and assuming no negative comments are received, authorizes the EO to make any non-substantive changes as may be required to complete the rulemaking file. Motion.
The
Second.
second still
Second.
hold?
Second.
Time to
I
nod your head.
second what you just read.
Thank you. Did you want to repeat it? Any public comment? Nope.
The call for the vote?
Yes, call for the vote. All those in favor of the motion? Okay, it passes. Unanimous. Okay, next. These are board action to initiate rulemaking awaiting notice. First one, proposed regulation related to renewal requirements. At the July 2013 board meeting, the board approved proposed text related to standardized reporting of convictions and discipline at the time of renewal for pharmacists, pharmacy technicians, and designated representatives, as well as require non-resident wholesalers and non-resident pharmacies to report disciplinary actions by other entities at the time of renewal. Board staff is preparing the required notice documents and anticipates initiating the rulemaking process in July 2016. The committee was advised that staff hopes to initiate the rulemaking by the end of July. We're getting close. How's this one doing?
The staff person that's working on it, she hopes to have the final documents completed this week, and it'll be filed next week with OAL.
So this one took 3 years to get far?
This one's been sitting there. Yeah. Low priority reg.
Sitting in our,
Wow.
And waiting for someone, waiting for we had that great big wedge of regulations to go through. And we're now starting to see light at the end of the tunnel, so I guess we're starting to fill it again.
Good. Does it still apply?
What?
Does it still apply?
Well, yes, as a
Okay.
matter of fact.
Okay. Thank you. Copy of the board-approved language, which has not yet been noticed, is provided in attachment 10. Okay, next, proposed regulations related to third-party logistics providers. At the July 2015 board meeting, the board approved text to establish regulatory requirements for third-party logistics providers. During the preparation of the required notice documents, board staff determined that additional modifications to the proposed text may be necessary. The committee discussed it and recommendation to return the proposal to licensing committee for review and identify a solution to update the reference to a prior version of USP 797 that is contained in section 1780 of the proposal. Copy of the board approved language, not yet noticed, is provided in attachment 11. So the committee recommends that we return it to the licensing committee. Don't have to make a motion to do that, right?
I'm sorry. I was keeping track.
It's
Where are we
going
at?
from one committee to another?
Comments?
So somebody want to make a motion?
So it's a committee recommendation.
Doesn't need a motion.
Oh,
We just need
Committee
to vote on it.
recommendation. Right.
so it says.
Public comment.
Any public comment? Okay.
Otherwise, we vote?
We don't have to vote,
Oh, we don't.
just a recommendation.
No, you,
Yes, please.
We have
you've
to?
got a motion, you've got a recommendation for the board to
I
take
thought it's
action on
not a
something.
motion. Anyway, okay. Let's vote.
All in favor?
All of those in favor of returning this to the licensing committee? Thank you. Next, board action to initiate rulemaking, comment period closed, awaiting further action by the board and licensing committee. We don't have to do that one. This is the one we handled this morning with the education.
Yes.
Okay, so is there, that's it except for any public comment on anything related to regulations? Nothing? Okay. Then that concludes my report.
All right, thank you, Greg. All right, we're moving into the regulations on, first one is item 9, discussion and consideration of proposed regs to amend Title 16 CCR Section 1703 related to delegation of certain functions. Okay, at the October 2013 board meeting, the board approved proposed text to delegate to the executive officer the authority to adopt regulation changes that are deemed to be without regulatory effect, in accordance with Title I CCR Section 100. At the February meeting of this year, the board approved proposed text to delegate to the executive officer the authority to approve prescription label waivers in accordance with Business and Professions Code 4076.5D. The 45-day comment period began on April 22nd and ended on June 6th. The board received one comment during the 45-day comment period, which is attached in your packet. At this meeting, the board has the opportunity to discuss the regulation, the comment received, and determine what course of action we wish to pursue. Among the options, 1, adopt the regulation as approved at the February 26, 2016 board meeting and notice for 45-day comment, or amend the regulation to address the concerns expressed by the stakeholders and notice the modified text for a 15-day comment period. So Lori, there was one comment.
Correct.
And that was basically a grammatical error comment?
Yes.
You're reprimanded.
Okay.
This wasn't mine.
So, and those are non-substantive changes that the board officer can make. Is there a motion on this item?
I move that we approve it as presented. And acknowledge the, I guess, the comments for the board officer to make those changes.
Grammatical errors,
Yep.
yeah. Okay, second?
Wait.
Sorry.
Isn't this the one that the errors were actually in the ISR? So the errors that the person who commented pointed out are actually in what's called the initial statement of reasons, and that is the document by which the board tells the public, here's the regulation we're working on, and here's why we chose the terms we chose. So it's actually not necessary to amend it unless there's somehow no substantive notice to the consumer. And the way I read these changes, I don't think that there's a question that the consumer didn't get notice about the actual regulation, so I don't believe we would have to make an amendment.
I actually wondered where because I went through the regulation a couple times, I couldn't find those less than an agenda. I'm like, well, I guess I'm just blind. But
Yeah, it's, so if you note that it says initial statement of reasons, 16 CCR. So it's, the initial statement of reasons is
Okay.
the document that goes to the public to explain why we did what we did.
Want to amend your motion?
yeah, I think we don't need to mention the changes. I think I'm going to move that we just approve the regulation as presented.
And Greg, you okay, or Cheryl, you okay with that second? Okay, any public comment?
Would you also like to delegate the authority to the executive officer to make non-substantive changes?
Delegating to the EO, you might as well keep going.
Yeah, yes, I would like to do that.
As
Cheryl,
necessary.
yes? Okay. All right, all in favor, raise your hand. Okay, moving on to item 10, which is proposed regulations to amend Title 16, 6 CCR Section 1744, related to drug warnings. So at the April 2015 board meeting, the board approved proposed text to amend Section 1744 of Title 16 CCR related to drug warnings. 45-day comment period began on September 25th of 2015 and ended November 9th, 2015. At our April board meeting, the board approved a modified text to address concerns expressed during the 45-day comment period, and we initiated a 15-day comment period. The 15-day comment period began on May 11th and ended on May 26th. The board received one comment during the open comment period. And that is from Ray Rabel. And it related to two items where he states a pharmacist shall inform. Exactly what does this mean to inform? If that can be satisfied by putting a little sticker on the prescription bottle, it is woefully inadequate. Minimally, these drug warnings should only be orally communicated to the patient or representative. I think inform is not very, it's pretty broad to let the pharmacist use their judgment. Right? Do we need to really be more prescriptive about that? No? Okay.
I think number 2, we might need to.
The second one is, why does the wording for the label in Part A, which states shall include a written label, and in Part B shall provide a written warning notice on the label, why are those different? So what do you recommend, Debbie, to modify that?
Actually, I was going to ask council if there's a reason why in B it says include a written label, and in the other portion I was just wondering if there's, it does seem, from what he puts here, when I looked at it, that does seem inconsistent, but I don't know if there's, if we should have the exact same verbiage in both situations.
I'm missing something.
Well, one says label and one says warning label, I think.
Written label on the drug container.
A written label.
A written label on the drug
It says a
container.
written.
It's in both cases, it's the same language. I don't see, in my version, we amended the second one, so it was the same.
Right.
I think the comment was from a prior version. I stared at this for quite a while,
Yeah,
trying to figure out what happened.
Include a written label on the drug container, include a written label, yeah, it's the same thing.
Yeah, but you can see on the Part B where the provider written warning notice on the label too has been stricken.
Right, we corrected
Double
it already.
strikeout.
Okay.
So
this
so
has
this
already
was our
been made.
second modified, right?
This has been released, right?
Yes.
So this is the final language in front of it. It's modified language, right? May 9th, okay.
So the change has already been made that was
Yes.
recommended.
Yeah, I was looking at that 45 day, the one below it. so
I
the one
know.
above it.
I won't tell you how long it took me though to figure that out.
Well, as you can see, I didn't, so you were ahead of me.
I just read it ahead of time, that's all.
So the staff is recommending that we adopt the regulatory language as noticed on May 11th and delegate to the executive officer the authority to make technical or non-substantive changes as may be required by OAL or the department to complete the rulemaking file. Is there a
So
motion?
move.
Victor moves second.
I'll second.
Debbie second. Okay, public comment? All in favor? Okay, moving on to patient-centered labels.
I'm sorry to raise this, but I'm going to ask that we step back just one quickly. Lori, the draft that's in the packet has a date of May 9th. Is that just the last date it was revised and it was actually mailed out on May 11th?
Correct.
Okay.
Yeah.
So even though it says May 9th, it was noticed on May 11th.
Yes.
That is the May 11th version. Thank you.
For clarity, can you make it the 11th?
Yeah.
The final, does that change any, it doesn't change anything, the date's the date, it doesn't matter. We're trying to track dates better for those of you that are trying to figure out what's going on here. We're having trouble with iterations of regs.
I don't think you want to change because it was noticed.
Okay,
You
all
can't
right, so it
change
might
what
be-
you
all right.
noticed. But I
Please
think you
don't
can
change it.
explain that maybe in the FSR that, the document bears the date May 9th because that was the date on which the edits were made or something. But it was noticed on May 11th.
Okay.
Okay, moving on. So we're okay with that, Laura? We can move on?
Yes, thank you.
Okay, next one is item number 11, which is discussion and consideration of proposed regulations to amend Title 16, CCR Section 1707.5, related to patient-centered labels. At the January 2015 board meeting, the board approved proposed text to amend Section 1707.5 of Title 16 CCR related to patient-centered labels. 45-day comment period began on October 23rd, 2015, and ended on December 7th, 2015. At the April board meeting, the board approved a modified text to address the concerns expressed during the 45-day comment period, and we initiated a 15-day comment period. The 15-day comment period began on May 11th and ended on May 26th. The board received several comments during the 15-day comment period. So the copies are attached in terms of the comments. The staff recommendation is to adopt the regulatory language noticed on May 11th and delegate to the executive officer the authority to make technical or non-substantive changes as may be required by OAL or the department to complete the rulemaking file. Any board comments?
I have a comment. I hate to do this, but I think that the name of the manufacturer, which is hanging off at the end down there under Big B, it was the board's intent to put the name of the manufacturer outside the patient-centered area anyway? Because I thought that was the board's intent.
So where are you looking?
I'm looking at 1707.5, Section A1, Big B. At the very bottom, the sentence that we added here with the strikeout and now reads, if in the professional judgment of the pharmacist, the brand name is no longer widely used, the label may only list the generic name of the drug and outside the patient-centered label, the name of the manufacturer. I think the intent of the board was, regardless of whether or not the brand name is no longer widely used, the manufacturer's name would go outside the patient-centered area of the label itself anyway, because it's relatively unimportant information compared to the patient-centered material.
You don't mention the manufacturer anywhere else in this reg?
No, I think what happened was when we made that correction, we inadvertently caused another problem we hadn't intended to do. And I didn't see it until I read.
I'm sorry,
reviewed the
but what's
packet.
the problem that we caused, that was caused?
Well, before we moved the manufacturer out of the patient-centered label, part of the label, to a different part of the label anywhere else, simply so that it wasn't taking that
Right.
valuable real estate out of that patient-centered label area.
Now we're only saying
And I
it's
think
when the
it was
brand name
Mary
is no
Staples that
longer-
actually caught it. Somebody else, I think it was your comment that noticed it.
And I think right now, the way it's written, if I understand this correctly, it's only outside of the area if it's a brand name that is commonly used. Point.
The brand name is no longer widely used.
Like
Label
Bactrim.
may list only generic name of the drug and outside the patient.
Just on the reject comments, you said the manufacturer name can be included in the patient center area. That's what I see on the staff recommendation comment right there. Is that what you mean?
It can be.
It said it can be included.
Okay, well, if that was the board's intent, then that's fine.
Yeah, so we need to make the corrections on that.
Well, but in the existing reg, doesn't it require that the name of the manufacturer, if you ignore all the, all the added language, it looks like the current regulation does require, if you're including the generic name, you also have to include the name of the manufacturer within that patient-centered area.
You have to include it inside?
That's how
there?
I'm reading it. Am I?
The label may only
Label?
list the generic name of the drug and outside the patient-centered label, the name of the label. I think it's that introductory clause, it's that if, in the professional judgment of the pharmacist, the brand name is no longer widely used. That's the qualifier for the rest of the sentence.
Well, now it's changing it, I think, is what.
Yeah, that was my
Right.
point.
So I think I'm with you, Victor, that you want to, where the name of the manufacturer is at the discretion of the pharmacy. So if we want to do
Yes, yeah,
that.
they could, yeah, if at the discretion of the
be-
pharmacist, you could put down the generic name and then the manufacturer name,
Okay.
either abbreviation or whatnot.
So would we
Include
say,
it.
and may outside the patient-centered area, the name of the manufacturer, so that,
May.
Oh,
add another may in there?
may can
That's
be.
permissive.
Yeah. So in the professional judgment of the pharmacist, the brand name.
4076, though, I think requires the name of the
Says
manufacturer.
may.
Says the brand name is no longer widely used, the label may list only the generic name of the drug, and may outside the patient-centered area, the name of the manufacturer. Does that make sense, Laura, or is that?
I think there's a comma missing somehow.
Something's
And
not right, yeah.
Something's not right, and it's right
And
there where you're talking about,
outside
it's
of
the and.
patient-centered-
It may list the generic name of the drug in the area, and then outside of the patient-centered area, the manufacturer. That's what.
The may list only the generic name of the drug, and outside the patient-centered area may list.
Name of the manufacturer.
May list the name of the manufacturer. How about that? Put may
Yeah.
list before
say
the
it
name of
again,
the
please?
manufacturer.
Or and may list
So,
the name
no, I
of the
think,
manufacturer
and
outside.
outside of the patient-centered area may list the name of the manufacturer.
It would be less confusing if you
Yes.
just said, and may list the name of the manufacturer outside the patient-centered area.
Right.
I think what happens, we
Turn the
drop,
words around.
we
Yeah,
dropped in
I think
that,
so, either way.
we dropped in that section, and then we left the name of the manufacturer at the end, and I think that's what happened.
Yeah, it was just an inadvertent.
This means we open this up for another 15-day.
We have time, Lori?
This may actually be a non-substantive change, but I think we handle it the way we did the other, which is we reach out to OAL and ask them their
Okay.
take on it and have the board authorize the 15-day if you need to.
What is
But
our
I-
time limit?
The 45 day, or the 1 year is up October 22nd.
Oh, so we got time.
Plenty
Yeah,
of
we have
time.
time. So the other thing is, we had a couple people, I thought, comment, and I think we've talked about this before, but I think we do get those letters again about if the prescriber prescribes for the generic, if we list the brand, and I know we had reject in the staff recommendations, but do we, since that was brought up I think by a couple, do we need to discuss it?
About whether, if they ordered Bactrim, we have to put sulfamethoxazole.
No, I think it's more if they ordered sulfamethoxazole, if we have to put Bactrim. But, I mean, their point is if the doctor writes it for sulfamethoxazole, do we have to put generic for Bactrim?
That's not, is that currently required in our draft?
Yes.
It is?
But currently, if the doctor writes, currently, we have to put the brand name in there regardless of what the doctor writes on the prescription, until the brand is no longer widely available.
In the
So
professional
Bactrim's probably
judgment.
not a good example, but a newer generic it would be.
Well, part of the concern, part of the reason why you're putting the brand and the generic name is that patients sometimes may have Bactrim sitting around the house.
Right.
And so if they get the generic drug on the label and only that name on the label, they won't recognize that Bactrim happens to be the same drug as the other container they've got with just the generic name on it.
So we're
I
talking
think
about
that was yeah, I think that's what the
5A1B.
comment in the past has been. But we received, we've received it again, I think we need to discuss it.
Because I think we mentioned it before, part of the concern is that if some doctor specifically wants to prescribe the generic name, because he, just like diphenhydramine, he wants to write for diphenhydramine for a patient to sleep, and he didn't want you to label as Benadryl, then the patient would yell at the doctor and say, why do you want me to prescribe me Benadryl?
Because
Well,
I wanted
actually,
your
if he
insurance
prescribed
to pay for it.
diphenhydramine, the patient slept a lot better instead of prescribing her Halcyon or Ambien. I mean, there's some rationale, medical rationale behind doctor
Yeah.
wants to write for generic, and if the pharmacist changed that, it would upset the doctor. I
don't
mean, you
know if
kind of
I'm-
destroy his purpose.
If you read that section right now, it's saying that you either use the brand name or you use the generic and the statement generic for. That's how we have it
Yeah.
right now.
Right.
It is required that you do that. So
If
if
he
the
prescribed the
diphenhydramine
brand,
comes in,
right,
it's
if
going
he
to be
prescribed the
Benadryl.
brand name, you could write generic for.
Well, the diphenhydramine comes in, it'll be generic, it'll be diphenhydramine, generic for Benadryl.
Correct.
And so I think their point is, like Victor's, is that sometimes you don't want to put that generic for.
Or it's really a commonly used generic. I mean,
But again, part of this was this particular provision was aimed at preventing med errors and duplication of therapy. Because the
Exactly.
patient doesn't recognize
And that's-
the
I
two
remember
names
that's
being the
what we
same drug.
discussed.
And it's probably going to have, I mean, if it's an old drug, then the pharmacist can waive it off.
Right.
If it's a new drug, then they could potentially have the brand at home and be getting the generic.
And that's why you left it in the professional judgment of the
but there,
pharmacist.
but
on the
is it
generic.
in the professional judgment of the pharmacist?
Well, that's something the board needs to decide. That's a
I
policy.
think sometimes you have to leave the professional judgment
Yeah,
here
because the
somewhere.
brand name's no longer
As
widely
a
used.
consumer and not a pharmacist, I find it very helpful to see both of them there.
But I think
I
the
think a lot
caveat,
of
what we have
consumers
now
see
is if
it
it's
that
not widely used. So if it's a,
Yes.
if Victor's situation comes up and it's a newer drug, then that's still going to be a challenge. If it's an old drug, the pharmacist can waive it off. But if it's a new drug, then they,
Right.
then the pharmacist's discretion, you can't.
Or if
So-
it's a drug that's been out generic so long, everybody just knows it by the generic name.
But in that case, the pharmacist can waive it off. So
Yeah.
it's just whether we want to give the pharmacist the ability to
Don't know about
waive it off
diphenhydramine.
when it's a newer drug.
But isn't that what we added, if the professional judgment, the brand name is no longer widely used, the label can only list the generic name of the drug?
Right, that's why we added that.
Okay, so we don't need to do anything with that then? They'll keep it as reject?
Right.
Is there any public comment? So I think from what I heard from Laura, what she's recommending, that if we want to move through this, is to go ahead and approve the language. You need to go through.
So approve the language change, and then in the event that it is determined to be a substantive change, you're going to authorize the executive officer to adopt the language, assuming no negative comments, and also delegate the authority to her. Well, either way, you're going to delegate the authority to her to make any technical or non-substantive changes as may be required to complete the rulemaking file.
All right, so can I make the motion?
Yes.
To
Go
adopt
right
the
ahead.
regulatory language as noticed on May 11th, is that right? Am I looking at the right date?
I think the text is actually revised on May 10th, but I think Lori indicated that it was noticed on May 11th.
Okay. And delegate to the executive officer the authority to make technical or non-substantive changes as may be required by the OA Office of Administrative Law or Department of Consumer Affairs to complete the rulemaking file. However, if we find out that the addition of the couple words by the Office of Administrative Law is ruled to be more than technical and non-substantive, then to go ahead and, I guess, reissue a 15-day comment period.
Right, and
Second.
you'll also authorize the executive officer, assuming there's
Oh, I
no
couldn't get it all.
negative comments,
Did
to
pretty good.
adopt the language.
Debbie, that was a mouthful.
We're glad to have Laura here. I'll second Debbie's motion.
Thank you, Amy.
Any public comments? Okay, all those in favor? Raise your hand. All right, moving on to item 12, which is discussion and consideration of proposed regulations to add Title 16 CCR Section 1776 related to prescription drug take-back. This has been a long-standing agenda item on the board meetings. At the January 2006 board meeting, the board approved proposed text related to prescription drug take-back programs. The 45-day comment period began on February 12th, 2016, and ended March 28th, 2016. In addition, we had 2 regulation hearings that were held on April 13th, one in Northern California and one in Southern California. At the April 2016 board meeting, the board approved a modified text to address concerns expressed during the 45-day comment period and at the regulation hearing. The 15-day comment period began on May 3rd and ended on May 18th of this year. At the June 2016 board meeting, the board reviewed the comments received during the 15-day comment period. The board made policy decisions regarding the content of the 15-day comments and instructed staff to make the recommended changes to the language and present the modified language to the board at the July 2016 board meeting. At this meeting, the board will have the opportunity to discuss the future of the regulation and determine what course of action it wishes to pursue. There are 3 drafts included in your packet. The first one contains the changes approved by the board during the June 2016 board meeting, and that one's dated June 8th, 2016. Draft 2 is a staff-recommended modified text dated July 1st, 2016. This draft contains changes that were made for clarity and consistency throughout the regulation text. Draft 3 is the clean version of that same draft, and this is provided for clarity so that you can review it without having all the colored strikeouts and underlining to make it clearer for the board to review. Now, I know that Debbie and I have spent some time with staff. I know Laura's been involved. There's been a lot of effort placed on trying to clean up this language. So what do the board members want to do? What do you think? I know, Debbie, you and I worked on this
Yeah.
a lot with,
And I did find, I think I emailed you and Jenny, I found maybe one little typo, and that's on the first page, 1776.1E3 says consumers may deposit prescription drugs, including Schedule 2 through 4. Isn't that supposed to be 2 through 5?
Well, it depends on whose regs you're looking, or whose comments. I believe the DEA language was 2 to 4, was it not? Somebody confirm.
I think it is.
I think it's, they have 2 to 4 in one spot and then 2 to 5 in another.
Thank you, I couldn't remember.
If
So,
he's also on page 9 is the same, and it was, so I wasn't, but somewhere I saw it was struck out that we had 2 through 5. Maybe it was
it's because we were making it consistent and using the same wording
Okay,
in
yeah,
all the
on-
sections where it occurs. So
On
that the-
12, what we struck out was 2 through 5, and on page 2.
but why don't we keep it as 2 through 5 if
I
it's,
think
if it
that's
stays
fine.
both? Because what are you going to do with 5? I mean, if it's not.
No, the DEA was clear they don't want Schedule 1 drugs, which people aren't going to know that they're Schedule 1 drugs either. So I think if the board wishes to go to 2 to 5, I think that's fine.
And that's probably a non-substantive change considering it's.
Well, you're going to have to go out to notice anyway, so, but I hope the board is narrowing down its final version of this regulation. We've had a lot of discussion, and what you're looking at in draft 2 is really an attempt by staff to make consistent from one section to another the comment, or the actual text that's there, so that we don't have inconsistencies throughout the reg. And so there were 3 of us that spent quite a bit of time going through this, trying to make sure after we worked with Debbie and Amy, so.
Yeah, and so I think, Amy, what we tried to do with the staff was to try to make everything be the same, so be consistent throughout all the pages, you know, because in some places it was called drug enforcement, some places it was DEA, sometimes it was collection receptacles and mail back envelopes, and sometimes it was the opposite, or packages and envelopes. So, I mean, so some of it's like nonsense type of stuff, but we worked very hard at trying to make it consistent throughout the document.
I had a couple.
And then to clean it up, just kind of make it flow better.
Just a couple of minor things, or one of them's minor, one of them I think maybe a little more than minor, but on the first page, when it describes authorization, section 1776, prescription drug take-back services authorizations, in the red section, it says through collection receptacles and mail-back envelopes or pharmacies. I think we need to make that and/or, because it doesn't, it is may offer. So just because you offer collection receptacles doesn't mean you have to do mail-back envelopes.
and/or mail-back
And/or
packages.
mail-back envelopes or packages, yeah. Just a very small minor. And then I did want to touch on,
So we need to probably do that consistently wherever we have that statement.
yeah, just to say that you don't have to do both. And the other one I had was regarding the section about a hospital, and I actually asked Laura to review this, because the DEA license of a hospital.
So take us to the section so we can.
Okay, let me see if I can find, I just had it, but I.
Actually,
I passed through
He and I discussed
it.
this with staff, and since we hadn't really discussed it, I don't think fairly in front of the whole board, we wanted to bring it back to the board before we just changed it in
Yes.
this draft.
So I'm talking about 1776.3 AC.
What page is that on, Amy?
That is on page 5 of 12 of the multicolored copy.
So it starts out
So
in
s-
hospitals and clinics?
Yeah, in hospitals and clinics with a pharmacy on the premises, which I understand is a requirement from the DEA for drug take-back to occur in a hospital. The collection receptacle must be located in an area that is regularly monitored by pharmacy employees. Now, I know last time that we had the board meeting, we discussed what employees, and I think that was a question we had for council as to define the employees. And it says, and not in the proximity of any emergency or urgent care areas. Now, my question is, since the DEA license of a hospital does not really belong to a pharmacy, it usually, hospitals are licensed as hospitals, and I mean, the ones I'm used to, the actual registrant is the CEO of the hospital or an administrator. The pharmacy has power of attorney. Does this still require that pharmacy employees monitor this? Because my concern is in a hospital, you're not going to place the take-back bin right next to a pharmacy, which is going to be in the basement, typically. Unfortunately, that's where pharmacies are in hospitals. But I'm concerned about the regularly monitored. That may be a concern from some hospitals to get involved with this. And can we kind of clarify what exactly is meant by monitored by pharmacy employees? Because if I'm working in a hospital and I spend all my time servicing patients in that hospital behind closed doors, I don't have patients walk into my pharmacy. Some patients don't even know where the pharmacy is in a hospital. And now we're saying, no, you're going to start monitoring this take-back bin that's on your hospital grounds. What is my concern is our expectation and whether the hospitals will want to participate. Because of the pharmacies, because they're going to say anything that happens to that, even if it's 4 stories up, it's going to be my responsibility, and I don't even look at it. I don't see it. What are the expectations we have? And is this a requirement that it be pharmacy employees?
So taking them a little at a time.
Yeah, I know that's a big one.
Right. So I think there's a little bit of a disconnect between who DEA considers the registrant and who this board thinks is the licensee. So it sounds like DEA, and I'm trusting those of you who actually are familiar with DEA permits and how they're issued to clarify if I get this wrong. But DEA issues the permit, from what you're saying, directly to the hospital clinic.
No, to the hospital.
To the hospital, well, or it's a hospital or a clinic that has a pharmacy,
or clinic.
right?
I thought you said hospital clinic, yeah.
Well, hospital/clinic, because that's the term that's used throughout the regulation. So the way that the DEA regs specify, they say the employee has to be an employee of the registrant. So for that person to be an employee of the registrant, they also have to be, for our purposes, the registrant is going to be the pharmacy. That makes sense.
And that's true for a retail pharmacy.
Right, and so the disconnect is that is it not the case for this board that the pharmacy within the hospital clinic is the licensee?
Yes, for our purposes, we license.
For this board? We
license a hospital pharmacy.
Okay, right. So the analysis that is reflected in the DEA regs is that first of all, a hospital or clinic that does not have a pharmacy is not eligible to have a collection bin. So DEA drew that line, a very firm line, and that's in, I think, 1317.75 sub G or sub I. So they specifically said, as long as it has to have that element. So the existence of the pharmacy at the site of the hospital or clinic is important, because if you don't have that, you don't get the collection bin. Also, the DEA regs say the registrant is responsible for all of these criteria. Those criteria include the qualities of the individuals who are allowed to sort of touch or monitor the bin. That includes the felony history. It also includes the requirements that they not have been denied a DEA permit or revoked, I think, a DEA permit. It also would include the employees who are responsible for doing things like reporting the theft or destruction, which is required under the regs. And I'm sorry, I don't have that citation handy, but that is also a requirement of the registrant who's following this. So the analysis that DEA did about the employee is they said, look, the employee is the person who's basically under the management and control, or who's under the the right to control the manner and by means by which the product is accomplished. The following criteria would determine whether the person is an employee of the registrant for purposes of the disposal, and this is right out of their reg. The person is directly paid by the registrant, is subject to direct oversight by the registrant, required as a condition of employment to follow registrant's procedures and guidelines pertaining to the handling of controlled substances. Subject to receive a performance rating or performance evaluation on a regular routine basis from the registrant, subject to disciplinary action by the registrant. So clearly it's somebody who's within the control of the body who's going to be making the decision. From the State Board of Pharmacy, I think that person is clearly the pharmacy. And I think the disconnect that might be happening is that if DEA's registrant includes the pharmacy but is truly the hospital in name, there needs to be a connecting of the dots. I did hear you say regularly monitored. I think the DEA reg only requires that it be monitored, that the employee monitor. So the location of the collection receptacle for most, it has to be in the registered location, and it has to be in the immediate proximity of the designated area where controlled substances are stored and at which an employee is present. Now, that's the baseline rule. Then there's an exception, and the exception applies to hospital clinics. And the exception says the collection receptacle can be located in an area, it does say regularly, I'm sorry, regularly monitored by employees, and shall not be located in the proximity of any area where emergency or urgent care is provided. So they've drawn the distinction between the employee is present versus it has to be monitored. So I think you can argue that based on the fact that this is an exception to the baseline rule of presence, that it does not require presence constantly. The distinction of what it does require, I think, is a little open. I think in the absence of DEA being specific about what that monitoring means, the board can probably fill that in. I would argue, like I said, that if the baseline rule is that it has to be present, but the exception for a hospital clinic is that it can be in a different location, a more remote location, that regularly monitoring doesn't require constant, the ability to constantly look over and see who's at that bin. So, but I do think that, the board would have, at least until DEA tells you what that means, if you have a requirement that the pharmacy employee monitor it, you can say what that means. So that would just mean we would have to add a term that says what monitoring for purposes of this section means. They check it once an hour, or they're walking by, they have staff that walks by it, or they have, it could be that as long as the person is subject to the control of the pharmacy, I think you could get at them being an employee. Because the issue of the employee has to do with who they're reporting to, and does the person have the knowledge and the information to do something if there's something going wrong with the bin. So it has to be somebody who can really monitor the collection receptacle, who knows what it should be or shouldn't be.
Yeah, and my concern isn't about the monitoring by pharmacy, because I think if it's in a pharmacy, it needs to happen. But that a pharmacy employee is involved, because they may not necessarily interact with that bin all the time or even go by it. So can a registrant employee monitor that and report it to the pharmacy?
I think as long as they meet the other criteria for employee, and as long as you could say they were a pharmacy employee for our purposes, which I think would kind of follow the others, the DEA. In other words, if they have some reporting relationship to the pharmacy staff, So if you're the head of the pharmacy within the hospital, and maybe there's a person who works 80% of the time for another department, but 20% of the duties include reporting to you about the collection receptacle. As long as there's that reporting relationship, I think you could argue that they're a pharmacy employee. But I think there absolutely needs to be a connection to the pharmacy, because the pharmacy is the body or the person that has the responsibility for making sure that DEA regs are followed with regard to the collection receptacle.
Well, can I ask a question? Because I didn't realize that you could have these kiosks either in the pharmacy or somewhere else in the hospital. Is that what you're saying the situation is?
For a hospital clinic, it can be located outside of the
Well, then,
actual
when,
pharmacy.
so when we start regulating what the hospital does, which is within the DEA regulations, are we still in our scope of regulation?
I believe so. I mean, I think as long as there's not a contrary DEA reg, which I don't see it.
No,
I mean,
there's other state agencies that regulate hospitals. So when did we cross over there, or can we, or did we?
You're really regulating the hospital, you're regulating the pharmacy, the person who's acting on behalf of the pharmacy, which is why I think there needs to be a reporting relationship. It doesn't have to necessarily be like, a full-time employee. As a matter of fact, DEA said when they modified this definition of employee, they made it clear that it could be a part-time employee.
So it could be somebody that's just like, right now we do in hospitals, monthly unit inspections. We inspect areas. So you could actually have somebody inspect the bin and make sure that it's going okay.
I'm sorry, I couldn't quite hear that.
Inspect it and give a report to the pharmacy director to
I
say,
think-
I went by it, everything looks okay.
I think as long as there was a reporting relationship with the pharmacy somehow, so somehow the pharmacy had the authority to say, I'm going to write you up for that because you didn't do it right. So somehow there's the ability to actually exercise the control over that person. I think you're going to get into some very detail. But
Yeah, and just on that line too, item D actually talks about the fact that we need to close the bin when the pharmacy's not open. So in a hospital, which is never closed, do we still have to go up there and close the bin?
I believe,
Even if it's 4 stories up?
I believe you
It's
would.
saying here that
because-
you have to. It's here in the text.
Because it says if the pharmacy is closed, and because the only reason that hospital clinic gets to have the collection receptacle is because they have the pharmacy.
Right.
So they don't have the pharmacy available, presumably there's some protection to the consumer, and there's some reduction of the risk, I think, of theft or diversion by having the monitoring occur by the pharmacy. Somehow, the pharmacy is exercising some monitoring of that collection bin, and if it's not available to do it because the pharmacy is closed, then I think that's when DEA drew the line of, we only want it to happen when the pharmacy's open.
Okay. If we could, I think I'd like to hear some hospitals, if there's any hospitals here that can opine on this to see whether it's a concern as well.
I'm fine. That'll teach you for coming to get some CE.
Good afternoon.
Hi, my name's Jim Walsh. I'm a brand-new board member of CSHP, and I'm also the pharmacy director of Mercy San Juan Medical Center here in Carmichael and the PIC. So the wording on 1776.3, particularly B, which I interpret to be that the receptacle is visible to pharmacy employees, limits where you can put this device unless you're
Right.
talking security cameras.
Hey, let me make sure I'm on the same place as you.
Yeah, that's what I'm reading.
1776.
Point 3 B.
So is that on that page 5? Let's see, 3.
Yes, 5 of 12. I'm
Could,
looking at it.
could we all agree we're looking at version 3? That way, because we start flipping back and forth. Is that where we're all at?
Page
We're on
5
the
of
one
12.
that's called the staff recommended modified
Yeah,
text.
I think right now it says the pharmacy maintaining the collection receptacle must surely fasten the receptacle to a permanent structure, and the
Page
receptacle shall
5.
be installed in an inside location where it's visible to pharmacy employees. Yeah, that means that if
That's
you're in a
Bees and Boyd.
basement, you're going to have to put it right
Yeah.
outside your
You have
basement.
to put it into your pickup room, and most places, like for my pharmacy, we're in the basement. It's a secure area. The patients can't even get down to it without a key card. So you're limiting, access right off the get-go. The regularly monitored by pharmacy employees, I think, is fine if you're talking security cameras. Maybe it's in an area where you constantly monitor, have a camera on it, and you can address any issues with security. But in general, if I'm a hospital and I read this, I'm kind of deterred, whether I'm a 24-hour pharmacy or not, from even participating. And I think that's the intent of the regulation, is to get more participation, because I would like to participate, but if it's going to be in my pickup area, which is about the size of this table, it's taking up a bunch of room and nobody can get to it. So there'd have to be, pick it up by the lobby, bring it back down by one of my pharmacy people, so.
Plus, you also don't advertise a lot of times where an inpatient pharmacy is located to
Yeah,
patients.
they'd have a hard time finding us. For reasons of security and controlled substances and other things.
Are you speaking to a hospital or clinic, or are
I'm
you speaking
to
to?
hospital and clinic.
Okay.
Yeah. So in general, the hospitals I'm familiar with, this would be a problematic,
So
You're talking about
you guys
B,
are talking about
but you would
B.
fall under C.
I'm talking about, if it
And
would have
C.
to be visible to a pharmacy employee, you're pretty much limiting it right there. But then, in an area that is regularly monitored by pharmacy, if it has to be visible, then it's regularly monitored by definition. If you're not 24 hours and you have to go and lock it each time, I might think that's kind of a, I don't know, a little bit of a pain.
So the DEA regulations at 1317.75 sub D are the ones that I was reading from before, where baseline for most places is that an employee has to be present, and it has to be in the immediate proximity of the designated area. But if you fall under the exception, which is a hospital clinic, you can locate it in a place that's regularly monitored.
But when you look at 1776.3C, .3B,
yeah.
it says visible.
So I think
I
maybe that there's a clarity, we could say except as provided in sub C, in the introduction, maybe?
We had one of these receptacles in our hospital for a while, and pharmacy had a key to it, security had a key to it, neither key could open it independently. It was in the floor above, which is accessible to patients. It was in a secure area because there were cameras around, but, it seemed to be working, but it was kind of in that time period when everything was kind of in flux, so we took it out. It was only there for about 2 months. It seemed to be working.
You removed it because of all the confusion around the regulations?
Yes.
So Laura, couldn't we just take out, the receptacle shall be installed in an inside location, take out the next part, but not located in or near emergency area nor behind the pharmacy counter? So take out where the receptacle is visible to pharmacy employees. Can we just take that out? Because then C kind of goes on to say that it has to be, if it's in a hospital or clinic.
Well, the problem is that the.
Oh, I see, I see what you're saying, except
That's
in sub C, because then that's saying that that's a hospital or clinic.
Right, so
Yeah.
I think what we can do is pull that particular language out and, and make it its own sentence within sub B. So the clause where the receptacle is visible to pharmacy employees, we can say, except as provided in sub C, the receptacle must be visible to pharmacy employees.
And I think it's important to keep that in there because in an inside location without the reference of the
Right.
pharmacy employees, they might perceive that as inside the pharmacy.
Yeah.
Okay.
You don't want either.
So then, when you guys
Subdivision.
look at C, you hospital experts, is there anything in C that needs to be modified?
I'd want to know if I could interpret C as regularly monitored as putting a camera on it with it going to security and pharmacy.
I would say that's regular monitoring.
Then I can look
I
at
would
that.
too, yeah.
Camera ought to be turned on, though.
As long as the camera's turned on.
It's not, yeah, it's not trying to figure out who deposited them. It'd be trying to figure out anybody tampering with the with the
That would
box.
provide better protection, just having somebody walk by it, to me.
I would
Still
caution
ATM
about who's
machines.
watching the camera, though. You've got a camera, is it just recording? Is somebody actually reviewing the tapes, or is this a live feed?
Well, it
So
says it has
that's-
to be regularly monitored by pharmacy employees, so,
Let them figure it out.
yeah. So as
Well,
long as it's
well,
regularly monitored by
no,
pharmacy
I think
Might not be a
employees.
single
No, I
answer.
think that's a very good point, because typically you have those cameras going to security or other places. I'm not sure, I don't know, do you have any cameras right now that are?
We have
For
11
pharmacy?
cameras in the pharmacy, and we have monitors in the pharmacy and in security. And the tapes record for 7 days.
But is someone in the pharmacy looking at those
Watching them?
tapes?
Yeah, it's right by the command center, yeah.
If someone broke into the bin, you'd have evidence that the
They aren't
bin had
looking
been
at
tampered
continually,
with.
but if the bin's all of a sudden not there because people steal ATM machines and
Or
such.
there's a hole in it.
Or there's a hole in it, or somebody's,
But so if the reg says regularly monitored by pharmacy employees, and that's, and you have cameras and they're, like in your pharmacy, like you are describing, are they regularly monitored though?
they are by security. Security monitors all the cameras, and they
This
scroll
is by
through in
pharmacy employees.
Well, it scrolls through all 11 cameras every 3 seconds or something.
And they usually keep copies.
I mean, I don't have somebody staring at it, but, you know,
Okay, so are we okay with that scenario?
Yeah, the other thing, could we ask the DEA to clarify that within a hospital, they do require you to close the bin when, especially if it's in the lobby or somewhere, when the pharmacy's closed? That just seems to me very difficult. That means you're going to have to go before you close up for your shift. Let me go lock the bin, which is, 4 floors up, and then, okay, I'm going to have to come back and unlock the bin when I come in the following morning. That just doesn't make a lot of sense.
So this is a question of ignorance. In most hospitals, does the pharmacy close? I was thinking the pharmacy was usually open 24 hour. I'm sure there's
Depends
small
on the
hospitals.
hospital. It depends on the hospital. There's some
Okay.
that do not have 24/7 operations.
Okay.
most are open 24 hours. In our system, we have 40 hospitals. 8 of them are not 24.
And so in those 8, if like Amy was describing, you had to lock down the receptacle, that would be a hardship?
It would be something that I would think twice about signing up for the program.
So maybe in those 8 locations, you wouldn't have it, and the other
That
32 you would.
Goes back to that conversation we've had is, the bin's locked. What am I going to do with my bag of
Yeah.
drugs? Let me just toss it down
What happens
there.
is they just leave it on us. They just put it on top or beside it. It's just like recycling places.
Yeah, and I think it's better just to have it and put it in there. At least it's contained.
Thank you.
Why can't they put it in the lobby instead of 4th floor up?
Oh, I'm just, 4th floor is just, it could be anywhere. You're right. It could be in the
They
lobby.
put it in the lobby. I
You're
mean,
right.
on
It
the
could
way
be in the
out, they could
lobby.
lock it up.
Yeah, could be in the lobby.
But the pharmacy is in the 4th floor, that's why.
No, they're usually in the basement, Victor.
Well, that's what
Without
she
a
said, you have to
view.
go 4th floor, because if
Only
the
until they get
pharmacy is
the
looking at the
venting for
4th floor,
syrup
she got to come all the way down to the lobby.
And I think we have to remember that the whole goal of this is to encourage and facilitate the access and not put in artificial limitations.
I agree wholeheartedly with that sentiment. That's where we're going, is we want the system to work.
Good afternoon.
Good afternoon. Do you want additional public comment on this matter now or later?
Go ahead.
So I'm confused about the registrant. So for the DEA, the registrant is the hospital, as you've been saying. So Laura, this is a question for you probably. But you're talking about the registrant on behalf of the BOP or for the BOP, but why would you make that? Because it's or an employee of the registrant that has to be regularly monitoring the
Right,
bin.
but the state board only regulates pharmacies. And for purposes of the state board, the license that it issues, where it has to be notified, is to the pharmacy within the hospital or clinic.
But can you see where my perspective then would be that you're adding that requirement that the pharmacy employee be the person that monitors, whereas in the DEA, it's the registrant employee, which would be the hospital employee.
It is the registrant, however, I think within the DEA regs say the registrant is responsible for for monitoring, for installing, managing, and maintaining a collection receptacle located at their authorized collection location pursuant to 1317.75 and 1317.80. That makes the DEA registrant responsible. Now, as a practical matter, there are specific requirements that the DEA registrant is going to have to do in order to properly comply with these DEA regs. It can't let people touch them who've had a DEA registration denied. Who's going to do that as a practical matter?
But it would still be
somehow that
new from you
pharmacy
guys.
is going to be the pharmacy who's the state board's licensee is going to be involved in that decision. Does that make sense? So it's not that, I mean, presumably the employee is also, who's an employee of a hospital that happens to be located, employee of a hospital, of a pharmacy who happens to be located at a hospital is also going to be the employee of the hospital.
Right, but I just think it's overly restrictive to say the pharmacy employee has to do the monitoring when I think that per the DEA, the hospital employee could do the monitoring. And I see, and we have they have to listen to you over me, obviously. Hi, I'm Thomas, I'm with the City of Santa Rosa staff. I forgot to say
Right.
that, sorry.
I understand the concern that you're having, but I don't see that there's a way for this board to regulate a pharmacy unless that employee has some reporting relationship with
Wait.
the pharmacy.
Why would this board have to regulate every portion of what's regulated under DEA because there are other things in DEA outside of what this board controls?
Because it's making the pharmacy is the body that's responsible for making sure that the DEA regs, the federal regs related to controlled substances are complied with. We hold that licensee responsible for that.
You're saying the DEA regs require the pharmacy to enforce the DEA regs?
The
Place of
DEA
responsibility.
regs, I think, would make I don't know enough about how hospitals are organized, so there's probably members on this board that can do a better job of that. But the way I see it, that the decisions that have to be made about who can touch what and who has the responsibility to maintain the collection receptacle that's located at a hospital or clinic is going to somehow have to tie to the pharmacy. There's no way that you can comply with the DEA regs unless there's some connection.
What do you think the DEA was thinking? I mean, because they already made up these regs, and they already said what you have to do. They must have had a concept of enforcement already in place.
I believe
I don't
that
think they left it blank for us.
Because, like I said, they say a collection receptacle can only, a collection by registrant in a collection receptacle can only occur at the following locations: hospital, clinics, with an on-site pharmacy. There's something about that. The DEA is calling out the on-site pharmacy as a requirement, and in their comments, they said that's because those are the people who know how to properly handle these materials so that they can safeguard and prevent diversion or theft or inappropriate conduct.
And I agree that the pharmacy employees would be the ones that would be packaging up the thing to send to the common or contract carrier if that were happening. But in terms of the monitoring of the bin, you're looking to see, is somebody punching a hole in it? Perhaps you don't need that same level of expertise.
And I guess where I'm coming with that is that I don't necessarily think that it's impossible that there's somebody who maybe has multiple reporting functions within a hospital that might have part of the monitoring function, or that the pharmacy employee who monitors it might rely on somebody else who does some more frequent monitoring, something like that. I think that there's a lot of permutations probably that would seem to satisfy both requirements. But ultimately, somebody has to be responsible for making sure that if that bin is tampered with, that it gets reported within 1 business day as required by the DEA regs. In order for that to happen, the person who is monitoring needs to know that if they see tampering or theft or substantive, they have to know, I've got to go tell the right person so that we can comply with our obligation to notify DEA.
Yeah, I guess I'm just unclear why that would be your responsibility as the BOP to specify who that person would be, beyond something that the DEA specifies themselves.
Hold pharmacies responsible for complying with federal law.
I'm not sure that's consistent with what the DEA was thinking. I'd be very interested in their view on this. But it doesn't add up.
Do you know, Laura, I'm kind of perusing this DEA regs, and maybe we want to talk about this, but there's a section in here that refers to hospitals, but they say retail pharmacies. So it says in there, retail pharmacies co-located with hospitals may be authorized to maintain collection responsible. And when I thought about it, I'm thinking the inpatient pharmacy. But it sounds from what I'm reading here, and I'm not an attorney, but I'm looking at this, is maybe that the thinking with the DEA is if you have a hospital and you have a retail pharmacy, which is an outpatient pharmacy, you're going to have that retail pharmacy manage the hospital. So it may be worthwhile to just take a look at, under the hospital regs, under the DEA, whether they really specify what type of pharmacy.
Can you tell me which section you're looking at?
I'm looking on the DEA regs on 75791. I'm looking at that's the page number, I guess, right? 75791. The very last column, about halfway through, it says, for the foregoing reasons, retail pharmacies co-located with hospitals may be authorized to maintain collection receptacles in accordance with these regulations.
That's the CFR that you're looking at. Unfortunately, that's not the version of the regs I have. I have that, just the text.
Can I take a
with me.
5-minute break? I can go get my copy.
Yeah, let's go do that. That'd be
I
great.
have a copy of what you're looking for right here. I'm Bill Pollack from Alameda County.
Hi.
And in the rulemaking package that the DEA put out in the explanations, it says, for reasons discussed in the notification, the rule generally requires that when authorized collectors choose to install collection receptacles, those collection receptacles must be placed inside their registered locations where controlled substances are stored. The DEA recognizes that hospitals and clinics with an on-site pharmacy can be unique in their design, and it is more effective to install collection receptacles at various locations within the hospital clinic depending on factors such as security and convenience and accessibility. As such, it would be challenging for authorized hospitals and clinics to adhere to the general rule to place collection receptacles in the immediate proximity where controlled substances are stored. So DEA clearly understands that in a hospital with like an inpatient pharmacy only, the box could be somewhere else, as long as it's monitored.
So I think, in fairness to Laura, we probably need to just take a look at this. So you want to do like a 10-minute break? And we'll be back here like maybe 3:45, and we'll continue.
Done?
Thank you both.
I don't want to miss my dinner, that's all.
Have it open? 'Cause I have it on my computer.